QB. So nobody probably got notifications that I was going live. Sorry. I had it set as unlisted because I didn't know for sure what time I was going to be able to start it. And I needed to like keep it unlisted in case so I could go and like edit the time to start. But yeah, so now we're here. Hi QB. And I just saw your message too about did I stream it? I missed that part you said. Part of it, not all of it. Part of it, not all of it. So I'm going to resume it exactly where we stopped. So, and the part that just ended was where where she told him, Brodes, that she was going to shoot herself. And he takes the firearm away from her and puts it in the locker at the lounge. That's what she's talking about right now. So, I need to know your thoughts, QB, on her testimony. What are your thoughts? I have thoughts, but I want to hear your thoughts. Ha ha. All right, here we go. We're going to get started. We're going to get started.
But he kept it from you, right?
Yes.
And you later found out that he had placed it in a locker at the cigar lounge?
Yes.
After that happened, did you realize that you needed a little bit of time?
Yes.
What did you do?
I made a plan to go and
You
be
haven't
with my
watched
friend.
any of it yet?
She is a therapist, but I just needed to get away, and she had an extra room, and so I just told her
Hey,
that
Sherry.
I needed
Hey,
her to
Morgana.
watch me and to just be there if I needed her. And
Was she in Little Rock?
she lived in Pine Bluff, Arkansas.
So how far away from Little Rock?
About a 45-minute drive.
Is she someone that you also worked with?
Yes.
At that point in time, were you pretty desperate for?
Yes, I even was gonna go and be with another friend of mine who was a clinician, but she lived in St. Louis. But she then, by the time it was for me to leave one friend to go to her, was then going through some marital issues herself, so I decided not to go to her house.
During the time that you stayed with your friend, were you speaking with Brodes?
Very limited.
When you got back to Little Rock, did you resume speaking with Brodes?
I did.
Were y'all still together at that point?
Yes.
I want to talk to you about April the 4th, 2019, okay?
Yes.
Can you tell me about the text that you got on April the 4th?
I had sent our regular good morning text. I didn't hear anything from him that morning. And then later in the afternoon, I seen where he had responded. And so I opened it up. And it said, I think our time is up. So he had broke up with me via disappearing text.
How did that make you feel?
I felt so used and worthless, and I just felt like trash. Like, who does that to somebody who they say that they love?
Not a bad person. How did you react after you read that?
I wrote a letter. I wrote a suicide note to my family, because I was just like, I'm tired. I'm tired of the pain. I'm tired of it all. And I just wanted I wanted the pain to end. So I wrote a note and made a plan to take my life.
Your Honor, may I approach the witness?
Yes.
Latasha, do you recognize that?
Yes.
What is that?
This is the note that I wrote to my family.
Your Honor, I'd ask that that be made the next numbered exhibit.
Any objection?
Objection on B22.
We'll show the suicide letter as exhibit 22.
Latasha, can you tell me the date and time of that letter?
April 4th, 2019 at 3:14 p.m.
Can you read that letter to the jury?
To my family, I'm sorry that I have let you down. I tried my best to be the person you all thought I was. I tried to be the person you could count on and be proud of. However, I have been depressed for a long time. I did well with coping until the past 2 years. My world changed February 24th, 2017. And the shit just keeps getting worse. I know what I have been through may be nothing to some. And you don't understand why I couldn't bounce back. I have fought hard for so long to keep things together. I didn't trust anyone to know deep down how bad I was struggling. Only a handful of people knew, but they couldn't help me. To my fellas, I'm so sorry that I have let you down. I have fought hard to be the best mother I could be to each of you. I pray that what I have taught you will stick with you forever. Please don't be ashamed of me. Mother, thank you for being my mother. Please know that although you didn't think I loved you, I really did. I wanted so badly for us to be close. There was many times I just wanted to crawl into your arms and have you hold me. I'm sorry for being a failure. I tried to make you proud of me. Words can't explain or express the pain I feel at this moment. I have pretended for so long to be happy. I have tried to work through the pain and begin to heal, but just as my life would have it, yet another loss appears to remind me just how much of a failure I am. I don't have any insurance and I don't have any money, so please just have me cremated and don't worry about a service. I don't want to be a burden. I'm sorry for letting all you down. I love you as all so much, and I wish I could live myself as much as I wish I could love myself as much as I love you all. Please take care of my fellas and always remind them of my love for them. I'm not being selfish. I just don't know how. I don't know. Okay, I don't know. This got out of hand, but it says, "I'm sorry for letting all of you down, and I love you all so much. I wish I could love myself as much as I love you all. Please take care of my fellas and always remind them of my love for them. I'm not being selfish. I just don't know how to continue bearing the pain I have felt for over 25 years of my life. With each loss, hurt, disappointment, etc. I've experienced through the years, it only added to my current state of mind. I thought I could continue to push through and be strong, the strong Tasha everyone know, but I can't. I'm weak. And I have been for over the past year and a half. I thought I would bounce back. I prayed consistently, but I guess God no longer hears my prayers since I wasn't doing His will. I'm not perfect. I've messed up so many times in my life. The thing I wanted to be the most successful in, I messed up not once but twice. Well, really 3 times. I will leave that for you all to find in my journal.
Patrick. You read that at 3:14 p.m.
Yes.
Where did you leave that?
I left it in my phone because I knew my little sister would find it because she helped me with my appointments. And that's the phone she used for making my appointments.
Did you leave it for her to find?
Yes.
What did you do after you wrote that note?
I drove to Sherwood to go purchase a gun
Why did you go purchase a gun?
because I didn't have my other one.
What was the purpose of the gun?
I wanted to end my life, and I felt like that was going to be the best way to do it.
When you went to that store, were you buying a gun to kill yourself, or were you buying a gun to kill someone else?
I was buying a gun to kill myself. I had a whole plan.
What was your plan?
I didn't want to do it at my house because my son lived with me. So I decided, as I was just thinking about all the pain, to go to this park in Jacksonville, Arkansas.
How far away from Little Rock was that park?
Jacksonville might be about a 20-minute drive from my home. And the reason why I chose that was because that's where Brodes was. He wasn't from Jacksonville, Arkansas, but the Jacksonville part of it was attached to him. And the name of the park was Johnson Park, which was attached to my second ex-husband. And then Ray Road, my daddy's middle name was Ray, so I just associated with all the pain from the men in my life, and so that's where I was gonna go.
How did you go there?
I was gonna drive in my car. It's from my home, it would have been straight down 440.
Is that an interstate?
Yes.
What happened while you were driving to Johnson Park?
As I was driving, I saw the Memphis exit, and so then I was like, go talk to him, Tasha. Just go let him see you. Go see why. And that's what I did. I just drove so I can see him face to face and hope that I can get something from him besides the fact that he broke up with me with a disappearing text. And as I was driving, he did text me, and as he was telling me that he still loved me. So I was trying to just figure out what was going on.
What did you do after you saw the Memphis exit?
I took it and I drove to Memphis.
Where did you go?
I went down to where I knew he would possibly be, which was a lounge, I guess it's in the downtown Memphis area called The Pocket. At the time, I think it was a fairly new lounge that he, when he got employment at Mississippi Boulevard, one of the members there had told him about.
Did you go to the Pocket because Brodes told you he goes to the Pocket on Thursdays?
Yes.
Do you remember what time you arrived?
I don't. I just know it was dark, and I know that I circled around for approximately 30 minutes trying to find a parking spot because I didn't know that you couldn't like park on the street. Like everything down there was paved. Like, and yeah.
Um, just to back up for a second, when you went to the gun store to buy the gun to kill yourself, what did you take with you?
Just my license and my debit card.
Where was your purse?
I guess I had left it at home.
Did you bring just necessities with you to the gun store?
Yes.
And you left the gun store right after you finished purchasing the gun, right?
Yes.
How did you select the gun?
I went with what was the cheapest that was on. They have a wall that has all the guns, the names, and the prices, and I just chose the cheapest one.
How did you select ammunition?
Whatever the guy told me to get, I got it. Cause I was about to walk out the store till he was like, do you need ammunition? I was like, oh yeah. And so he told me whatever he recommended, I was like, yes.
And did you see on the video where he was showing you different types of ammunition?
Yes.
Is that what he was saying?
Right. And I
so
told, you couldn't hear, but I was like, I don't know, just whatever you tell me.
When you left the gun store, what did you do with the gun?
I think it was still in the bag. I went home because I did, wanted to leave my son something. So I had stopped at the ATM and got out whatever money I could get. And so when I got home, I put that in his room, and then I changed clothes, and I dumped some bullets out on the bed and just grabbed a handful of them and took the gun and left the house.
What did you do with the handful of bullets in the gun?
Once I got in my car, because I was trying to hurry up and leave because I didn't want him to come home while I was there, I loaded the gun in my car. And once whatever was left over, I put everything into my coat pocket that was sitting in the passenger seat.
Now, when you parked downtown, where did you go?
I started walking in the direction in which I knew the lounge was. And once I got on the street, I started walking up the street, and I actually saw Brodes coming out of the lounge, and I walked past him.
Were there any rules in your relationship regarding how to behave when you saw him in public?
Yes, I was not to approach him because I never knew who he may have in his company, so I was not to approach him, but if he acknowledged me, then I could have, talk to him.
Did you come within his sight?
Yes,
Did he acknowledge you?
yes.
You actually walked
I
right.
I walked past him, and so he said, so you're just gonna walk past me and not say anything?
At that point in time, did y'all engage in a conversation?
Yes.
After you talked with Brodes, what'd y'all figure out?
Well, we decided that, because his thing was, I still wasn't wanting to be on board with him and this non-monogamy and have been able to see other women. So we came to I told him, well, we still haven't told Tab. You've always said something about telling Tab, so we haven't told Tabitha. And, he said, okay, we'll tell Tabitha. He told me to go to the apartment and just talk to her about tenants until he got there, and that once he was there, we would tell her. He had to go to his boss house to drop off something. And so he gave me a backstory as to what to tell her if she asked me while I was in town, and we left. But before leaving, we came to the resolve that once we told Tabitha about the relationship, we had a trip that was planned to go. We was going to Kentucky. If she said yes, then that would be a new start, a fresh start. But if she said no, then that would be the trip that we would end.
Did Brodes indicate to you that he was going to tell Tabitha while y'all were at the apartment
Yes,
about your relationship?
yes.
And what would have happened, or would you have been allowed to tell Tabitha without his okay?
I didn't know.
What, would you have been able to continue a relationship with Brodes if you had done that?
No.
So I want to talk to you then about when you left downtown, okay? Where did you go?
I put in the address that he had given me, and so that address did say Collierville. I didn't know how far away it was or anything. I just placed it in the GPS.
Do you remember what time you arrived at the apartment?
I know it was late. I just remember when we were there and we were talking, I remember the news coming on.
Probably around 9 o'clock?
Yes,
So you left Little Rock, Arkansas at approximately 5 o'clock, right? And drove to downtown Memphis, right?
yes,
That takes about 2.5 hours.
yes.
How long would you say that you were talking with Brodes?
We talked for a while because I remember the valet pulling the car up a ways and getting out and just, because he was sitting in there waiting on him and we never did, so he just pulled it up and we continued to talk.
So then you left downtown, it was dark,
Yes,
drove to Collierville.
yes.
What did you do when you arrived at the apartment?
I circled around because I couldn't, it was dark and I really couldn't see like numbers or anything. So I circled around, and then I guess eventually I found the building number and I parked and found my way to their apartment according to the address.
If I may just have one moment, Your Honor. This is part of Exhibit 12. Latasha, is that your car?
Yes,
Is this also a photograph of your vehicle?
yes.
Which vehicle is yours in that picture?
The silver one?
This one?
Yes.
While you were sitting in your car, did you call Brodes?
I did, and I shared with him that I was a little nervous and could we just go somewhere and talk? And he said, no, we're going, you wanted to talk to Tabitha, we're going to talk to her.
Did he answer every time that you called him?
I didn't call him a lot, but I did that night.
Before you walked inside, was there a time that you called him and he didn't answer?
No,
Okay, not that you recall?
not the right call.
After you had talked to him and he said, no, we're gonna do this, what did you do?
I went to the apartment and knocked on the door.
Were you wearing your coat?
Yes.
When did you put on your coat?
When I got out of the car to go to find him at the lounge.
Is that when you were walking around downtown at night by yourself?
Yes.
Did you ever take your coat off after leaving downtown?
No.
When you left downtown, how would you describe your feelings?
I was a little hopeful. I was like, okay, maybe, we can get some resolve. We can get back to normal. And so that's what I was focused on.
And when he insisted on telling Tabitha, did you get even more hope?
Yes,
So what did you do? Did you get out of your car?
yes, I got out of my car.
Were you still wearing your jacket?
Yes,
Did it register to you that you had a gun in your pocket?
it did not.
Did you go to the apartment?
I did.
What did you do when you got to the door?
I knocked on the door. And I can't remember, but I ended up bending down. And that's when she said, I'm not going to open the door for someone I don't see. And so I knocked again. And that's when she was like, Tasha, is that you?
What do you mean you bent down?
I don't know if, I couldn't remember if it was time or sure or something. I just remember bending down, which is why she didn't see me when I knocked the first time.
You just don't remember?
No, I don't, yeah.
Who answered the door?
Tabitha.
What did she do when she answered the door?
She, once she opened it, she embraced me and said hello and welcomed me in.
Did you go inside?
I did.
Where did you go when you went inside?
She positioned for me toward the couch, and she sat on one end and I sat on the other.
And that would be Your Honor, if I may put, this is part of the cumulative exhibit. Is this the couch that you're referring to?
Yes.
And you were seated on this side,
Us.
and Tabitha was seated on this side?
Yes.
Did you talk to Tabitha?
Yes, we talked. We talked about tennis, but right before we kind of got into the tennis talk, she had made a phone call to Brodes.
And what did she say to him?
She told him, she asked how long it was going to be before he got there. And then she told him she had a surprise for him.
When Tabitha let you into the apartment, did she close the door behind you?
Yes.
You and Tabitha were sitting alone in the apartment with a closed door, right?
Yes.
Would anybody outside of the apartment have been able to see in through that door?
No.
How long did you sit talking with Tabitha?
Again, I know the news ended up coming on, so maybe 15 minutes or so.
At any point, did you pull your gun out and threaten Tabitha?
No.
At any point, did you verbally threaten Tabitha?
No.
At any point, were you trying to hurt Tabitha?
Not at all.
Were you happy to be there about to have this conversation with Tabitha?
Yes.
Was Brodes there yet?
No.
Now, I want to talk to you about when Brodes Perry arrived, okay?
Okay.
When he walked in the door, could you see him?
Yes.
Can you describe his demeanor when he saw you?
When he came in, he didn't look surprised or anything, which is what I thought he would do since he knew I was gonna be there. But he was just like, I think Tab was like, surprise. And he was like, this not a surprise. I thought you had some keto cookies for me. And from there, he was like, what are you doing here? And then I went with the story again that I was in town for a conference. And we just kind of started engaging in small talk. He came and sat beside me. And then after about a minute or so, was like, would you like a pour?
What is a pour?
A pour is some bourbon.
Did you accept the pour of bourbon?
I did.
Where was Brodes seated?
He was approximately a foot or two from me.
I'm putting back up from the cumulative exhibit,
That blue chair?
this blue chair right here,
Yes.
and you were seated here,
Yes.
and Tabitha was still seated here.
Yes.
After you accepted the pour of bourbon from him, did he make any comments about you drinking?
he came back and sat down, and as we were talking, he would make references to me drinking and would say, well, I think you're gonna have to stay the night. So I'm thinking, okay, well, this is about to get into this conversation. But he never would give me eye contact. But he would continue to make, like, we have to clean off the bed in there because it has a lot of clothes on it. And, but I'm still looking at him to get, like, to see where are you going with this. But he never did lead into the conversation. He actually started asking me questions like, so where are you staying in Memphis? And I'm like, that wasn't part of what you told me you was gonna say. So I don't know Memphis. He knows I didn't know Memphis. And so I didn't know what to say. I finally said an Airbnb. And then Tabitha was like, where? And I was like, downtown. And then that conversation ended. And he continued to say something about me staying the night, but never going into the conversation of what we were supposed to be talking about.
Had you ever been into that apartment before?
No.
On April the 4th, when you were there, what part of the apartment did you go into?
I walked through the front door, which led into a small little hallway and right into their kitchen area.
And then into the living room?
And then into, yes.
Did you go into any bedroom?
No.
Your Honor, this is part of the cumulative exhibit 13. Did you ever go into the guest bedroom?
I did not.
What is all over the bed in the guest bedroom?
Clothes?
Had you seen that?
No.
But those are the clothes Brodes was talking about?
Yes.
When he was talking about clearing off the bed and you sleeping over, did you think that was his jumping off point to talk to Tabitha?
I thought so.
How were you feeling at that point?
Very nervous.
Were you also excited?
I think I was more nervous because I just didn't know which way it was gonna go, but hopeful.
At some point, you lost hope,
Yes.
and you said you were gonna leave.
Yes.
Why did you decide to leave?
I saw that it wasn't going anywhere. Like I said, he was not giving me eye contact. So I knew, or I felt like he had changed his mind. And I just didn't want to keep sitting there feeling, at that point, stupid.
What happened after you said you were going to leave?
Tabitha got up, he got up, and so she began to tell me about watching for the police, you know, because I had been drinking.
Had you drank a lot?
No, not at all, but she still was just letting me know. And she began to walk toward the door, and I asked him, would he walk me out? He said no. And I said, why not, sir? That's Southern hospitality for you to walk a woman outside when it's dark. Because I wanted to just get him to see, like, what happened. Why didn't you follow through? But he refused to walk me out. So Tabitha opened the door and was walking out. I was still trying to get him to walk me out. And as I reached into my pockets to get my keys, I remember being outside the door, and then the next thing, I was standing in their kitchen.
Do you deny that you shot Brodes Perry?
I do not.
Do you deny that you shot Tabitha?
I don't, but I know it wasn't intentional.
Did you mean to shoot Tabitha?
No, I wasn't trying to hurt anybody.
When you went to that apartment that day, did you intend to use your gun on either Brodes or Tabitha?
No.
When you went there, what was your purpose in going there?
Thinking that I was gonna get some kind of ending to the relationship.
And what do you mean?
Like, okay, of course, after I got to, you know, talking to him at the lounge, we had a plan. It was either gonna be a start or an ending, but it was something that I could see, like I knew it wasn't just a disappearing text but still I love you, you know. So I went to the apartment, I guess, for lack of a better word, to get some resolve.
Did you have hope, given that Tabitha was open to the open marriage?
I was nervous about that because, like I said, he had told me she had these rules about not nobody that you know and things like that. So I'm like, she knows me, so I don't know what that was gonna be like. I didn't even think about anything beyond that.
As far as Tabitha goes, this is a person that you became friendly with, right?
Correct.
How did you balance that with having an affair with her husband?
It was very hard. She, like, we started off, she had approached me to invite me to lunch. It came out of nowhere, and I didn't know, like, what was really going on, because by this time, Brodes had been talking about us being sister wives, and so when she asked me, I was a little confused, because I'm like, okay, you know, has he talked to her about it? But she never said anything about our relationship. Even when we began to play tennis, it was her who initiated it. So it was uncomfortable for me, but we were friendly. And it was hard, but I still did it because I wasn't going to tell her, because I love Brodes.
When Brodes told you that he wouldn't walk you outside, he said, Tab will do it. How did that make you feel?
Rejected, unworthy, stupid. I was so stupid. And it hurt so bad.
Were you angry or were you hurt?
I was hurt.
Were you thinking clearly when you pulled the trigger?
No,
Were you reacting to that situation?
yes,
Was that a traumatic situation for you too, in retrospect?
oh yes. I hate what happened. I'm so very sorry. I never wanted to hurt anybody. I've spent most of my life helping. I never would intentionally try to hurt anybody.
Did you ever plan to kill Brodes Perry?
Never.
When you drove to Memphis, were you driving to Memphis to kill Brodes Perry?
No.
Why did you drive to Memphis?
I drove because I just wanted to see him.
Why?
I wanted him to explain why he did that.
Did you hope he would say, we can be together?
Yes,
Did he give you that hope when you went to the apartment?
he did.
Did he yank that hope away?
He did. As he often did.
Did you break in that moment?
I shattered.
Did you ever intend to hurt Tabitha?
No,
Did you even realize that you had shot her?
no.
That's all I have.
Cross-examination.
Ms. Daniels, I'm going to take you back to April 4th, 2019, at around 4 o'clock. You remember yesterday when we introduced that surveillance footage of you at the gun store, right?
Yes. Yes,
And you know that that was you in the gun store.
that was me.
And you purchased a gun that day.
I did.
And you also purchased ammunition that day.
I did.
And when you went to that gun store, you brought your state-issued ID, correct?
Yes,
And you brought your credit card, correct?
I did.
And once you left with that gun and the ammunition, you didn't go to Jacksonville, did you?
No,
You drove to Memphis.
no. I
You-
drove home.
but you eventually ended up in Memphis, did you not?
That is correct.
And you chose to go see Brodes Perry, correct?
Yes, I chose to go see him.
A man that you chose to be involved with.
When I first encountered Mr. Perry for counseling, I did not choose to be with him. I went to him for direction, not a relationship.
It's a yes or no question. You chose to be involved with him after you met him, did you not?
Yes,
And when you got to Memphis, and after you talked to Mr. Perry, you drove to his apartment, correct?
yes, I drove to his apartment.
And from Sherman, Arkansas to Memphis, it's about a 3-hour drive, right?
According to what has been said, I wasn't counting.
And when you got to that apartment, you talked to Mrs. Perry.
Yes,
And when you got to that apartment, you stayed there, you talked with her for about 20 minutes. Correct?
yes, we talked for about 20 minutes.
And then once Mr. Perry got there, you talked to him.
Yes,
And while they were gracious enough to walk you out of their apartment after an unexpected visit, you got your gun out, didn't you?
it wasn't unexpected for him.
But for Miss Perry it was.
It was.
And after you exited, you decided to take your gun out, correct?
No,
And after you exited, you shot Mrs. Perry, did you not?
my
Yes or no?
actions resulted in them being shot, yes.
And then you shot Mr. Perry, did you not?
It wasn't a conscious decision, but yes.
But you didn't do it because you lost control. You did it because you thought you deserved it.
No, I love Brodes. I would have never intentionally hurt him. No, ma'am.
You did it because he broke your heart.
No, ma'am.
No further questions, John.
Were you in a good state of mind that day?
I was not. I was
That
not.
whole day?
I was not my healthy self. No.
When you came to Memphis, did you come to Memphis out of anger or out of love?
I came out of love.
Did Brodes expect you to be there when he walked in?
Yes.
Did that visit go the way that you expected it?
It did not.
Did it end the way you expected it to?
It most definitely did not.
Did you go there to hurt anyone?
No, I did not.
Who did you plan to hurt
I
that
wanted
day?
to hurt myself. I wanted to end my own life that day. That's it, and that's all.
That's all I have, Your Honor.
No recross, John.
You may stay. You may call your next witness?
Your Honor, may we approach?
Yes.
Ay, ay, ay. Ay, ay, ay. Thoughts. You guys put your thoughts in the chat. I need to know what y'all think. QB, I keep wavering. Like I'm waving back and forth. Like 1 minute I'm thinking this poor woman, but then in the next minute I'm thinking, you know what? Teenagers handle this better than this adult. Teenagers in broken up love handle this better than this. So I still want to know why she reloaded. Right?
You may call your next witness.
Your Honor, that concludes our proof on behalf of Ms. Daniels. We rest our case.
What happened to all their witnesses?
We have heard the proof in this case. I'm going to excuse you for the day. After hear my speech, we're still not ready to discuss the case, okay? So I'm gonna excuse you for the day.
I love her.
Go have dinner, get a good night's rest, and we'll be ready to work in the morning. So I'm gonna show you an excuse so that you can leave your notepads and your pens in your chairs.
How many witnesses did the defense have altogether? Does anybody know? Personality and all, she is the prettiest thing, right? She's super cute. She's very mild-mannered, though, for a judge. Like, I can't imagine her getting mad, you know? 3 total. So, see, I missed the other 2 yesterday. I missed the other 2. I have to go back and watch those.
Yes, Your Honor, at this time, we would like to renew the motion for judgment of acquittal. As to count 1, we would submit that there has been no evidence of premeditation, most certainly no evidence of cool and calm reflection and judgment. And ask the court, if you let this proceed to the jury, that it not proceed past a 2nd degree. And then as to count 2, Your Honor, I did some research during the break, and this is an interesting topic. So what we have here is we have 1 count of first degree versus Brodes Perry, 1 count of criminal attempt first degree versus Tabitha Perry. State v. Millen addresses the issue where if yes, Your Honor, I do. Except my computer shut down while I was talking. Millen v. State is Supreme Court of Tennessee, 988 Southwest 2nd.
Say it again.
988 Southwest 2nd, 164. And what this case dealt with was a person attempting to kill person A and instead killing person B. Person A was fine. What the court said is that in that instance, that should be treated as a felony murder, a murder in the perpetration of an attempted premeditated murder. So, then we move to Kimbrough v. State, which I will have to pull up the site on, which was decided in the early 90s and said that in Tennessee, criminal attempt felony murder is not an offense. So what we have here is an allegation of attempted premeditated murder, where that person was in fact died, and then an attempted murder during that, allegations of an attempted murder during that premeditated murder, which, if Miss Perry had died, would have been a felony murder. Except attempted felony murder is not an offense in Tennessee. So unless there, I think that those 2 cases together preclude transferred intent for that criminal attempt first, when the person that was intended to be shot was. It is a very unique and interesting interplay of the law, and it's But I do think that we absolutely have no evidence that Ms. Daniels was attempting to even shoot Tabitha Perry, much less kill her. The evidence that Tabitha Archie provided, she told police that she did not even think that Ms. Daniels was trying to shoot her. So, Your Honor, I would submit, again,
I like
as to
her a
Ms.
lot. I like this
Tabitha
defense
Perry,
attorney.
that it is more appropriately a reckless endangerment. And I'm still working on that site for Kimbrough. And Your Honor, if the court does not hold the criminal attempt to the jury, then the employing a firearm would not apply as well unless it got down to a criminal attempt, to a reckless endangerment. But again, I don't think that the necessary mens rea for criminal attempt first-degree murder has been established, and I don't think that the transferred intent is appropriate in that context.
Same.
That case, as I understand it, probably does not preclude transferred intent, and that's a doctrine that's well established. She was trying to kill somebody else and hit somebody else, and that's transferred intent. It's in, like, as I said before, it's in the jury charge. There's absolutely proof of premeditation on the first degree murder, at least taken in a light most favorable to the state. She went to Arkansas, bought a gun, drove 3 hours, showed up at his house and shot and killed him. So again, I think they're jury questions, and ask the court to overrule the motion.
Okay. I'm gonna have to look at those cases. I'll give you a ruling on that in the morning on those last two, cause I'm gonna have to read those, and you can give me that cite for Kimbrough v. State. But I can go ahead and rule on the first degree murder. And the standard again is that after viewing the evidence in a light most favorable to the prosecution, any rational trial fact could find beyond a reasonable doubt that the defendant is guilty of the offense. And based on the court's previous ruling and even hearing the additional proof presented by the defense, it's simply a jury question as to what her state of mind is. And so I think at this point, there's enough evidence for this matter to proceed to the trial on the first degree murder charge. And then as far as the criminal attempt first degree murder and the employing a firearm, I need to look at those cases, and I'll give you a ruling in the morning.
That citation on Kimbrough, which is Kimbrough, is 924 Southwest 2nd, 888, Tennessee, 1996.
And can you give me that site again on Millen? It's Millen?
Yes,
And
that is 988
988, okay.
Southwest 2nd, 164, Tennessee, 1999.
Okay. All right, I'll look at those cases and I'll give you a ruling on that in the morning. So, I've sent out the instructions. If you could review those and let me know, what changes we can have a jury conference in the morning before, we charge the jury. But I'm gonna show you excuse, for the day so we can adjourn for the day.
Real quick, before we
Yes.
adjourn, can we approach real fast?
Yes.
I think so, QB. She's been fighting pretty hard for her, and I like her a lot. Hey, Margaret, I agree with Morgana too. Moral of the story: he was a POS, but no man is worth going to prison for. Oh, also during the opening statement, she said that he had told her that his wife was on board, but then she said she asked him when he was going to tell her. Yeah. That was a little confusing. Definitely like the defense attorney. She's fighting for her as she should. When you watch the arguments today for jury instructions, it becomes even more apparent. She is really fighting for her. Oh, good. Good. I really, really like this defense attorney. I like her a lot. Okay, now we're going to scooch on over to today. And apparently we'll be doing a lot of fast forwarding as there's a lot of breaks. So hold on, let me go find that one. Let me go find that one. Share this tab. All right. Little short breaks. Just ate a Kit Kat with no wafery stuff in it, just a block of waxy chocolate. You got ripped off, ma'am. That was a rip out. All right.
B. Claxton, the defense had provided me with some cases. I'll tell first.
Okay, there we go.
But the criminal attempt, first degree murder, and employment of firearm, the defense had provided me with some cases. Also, Mr. McAlpine sent me
A
a
rip out.
case as well, State v. Claxton. W20090167
It's a kid with no cat.
And so after reviewing those cases,
Oh, that was funny.
again, the standard is, after viewing the evidence in light most favorable to the prosecution, any rational trier of fact could find beyond a reasonable doubt that the defendant is guilty of the offense.
Who wants a kid with no
And
cat?
Millen versus State laid out what the standard is. In short, if evidence demonstrates that the defendant intended to cause or result the death of a person, that he did so with premeditation and deliberation, then the killing of another, even if not the intended victim, intended result is first degree murder. So also, State v. Claxton sets forward things that can be considered for premeditation: the use of a deadly weapon upon an unarmed victim, the particular cruelty of the killing, declarations by the defendant of the intent to kill, evidence of procurement of a weapon, preparations before the killing for concealment of the crime, and calmness immediately after the killing. And so, in considering those things, the court finds that there is sufficient evidence for this matter to go forward with the jury, because although the defendant may not have intended to kill Miss Perry, the law says that all that's required is that she had the intent to kill a person, and that person would have been Brodes Perry, who was shot multiple times. So, in considering all those things, the court finds that there is sufficient evidence for this matter to proceed to the jury. I know there was some indication about felony murder, but that case also, it says something about criminal attempt murder whenever it's not the intended victim should be felony murder, but that case also says that it can be criminal attempt premeditated murder as well, just not felony murder, just when it's not the intended victim. So the court finds that there's sufficient evidence, and because the court finds that there's sufficient evidence on criminal attempt murder 1 and count 2, the court also finds that there is sufficient evidence for the case to go forward to the jury on employment of a firearm. As indicated in my previous ruling, the defendant used the allegation that she used the firearm in commission of the criminal attempt murder, which the court finds that there is sufficient evidence for that to go forward to the jury that she did so intentionally. So the court's going to deny the motion for judgment of acquittal at this time.
Thank you, Your Honor.
And then there was a second issue, and I guess we can approach it about that. We can approach it about that. And I made, and I made one more correction, on the criminal attempt first degree murder. And I think she sent that out to you. Were there any, corrections or anything from what, the parties saw?
I did, Your Honor. I don't know if the state wants to go first.
I just have one issue that and it's always been something I haven't understood. So when the definitions of intentionally and transferred intent is in second degree murder, but not in first degree murder, and I don't understand why that is.
You said second.
Right, and so my position is that that language should be in the charge for murder one, because it is a criminal attempt murder one. It doesn't
Criminal
affect,
attempt second degree murder, or just second degree?
well, so, yeah, so the transferred intent element is, so the criminal intent, by the time you get there, the court is saying, I've already defined.
I changed that.
Oh, did you?
I did.
Okay.
Because the criminal attempt, with serious bodily injury, I included, hold on, let me make sure she sent you the correct version.
And she may have. I
We
just-
got a corrected one last night,
Okay, it's another.
or this morning,
I,
actually.
now, let me make sure.
That fixes my issue.
Okay. Did you have anything else?
No, ma'am.
Okay, all right,
I just note my objection to the change.
okay. All right. Did you have any other changes, Ms. Dukes?
Yes, Your Honor.
Okay.
On page 2, this is a unique situation in that at the last paragraph, or the last sentence of the paragraphs regarding first degree and criminal attempt first degree, it says that Latoshia Daniels pleads not guilty to every count as encompassed, to every charge as encompassed. And we are not saying that she is not guilty of all of those offenses. We are saying that she is not guilty of first degree murder, she is not guilty of second degree murder, that this is at best a voluntary manslaughter. So I would like to take that language out, or at least change it to has pled guilty to the originally charged offense, or something along those
Okay,
lines.
which part are you talking?
It's page 2, it's the last sentence.
Oh. The defendant pleads not guilty to each and every offense and breaks it out. You just want me to take that out completely on each one of them?
Yes.
Okay, that's fine, I can do that. Any objection from the state?
No, ma'am.
Okay, yeah, I can take that out. No problem. Anything else?
Yes, Your Honor. Regarding the section on defendant testifying,
Let's see.
it's on,
I know they're not numbers, so, let's see.
It's after direct and circumstantial evidence.
Okay, defendant testifying, yes.
Your Honor, I would just ask, it does say like subject to all of the rules that apply to judging the credibility of other witnesses. I would just ask that it be made clear that just like with other witnesses, the law presumes that a testifying witness is telling the truth, and to be given a full and fair consideration. I mean, really, that first paragraph of credibility of the witness, minus all of the factors that they need to look at, I would suggest adding into that defendant testifying so that it's clear that the same rules apply for Ms. Daniels as applied to all of the other witnesses.
So what are you suggesting we add? What language are you suggesting?
The, if you go to, so it's kind of cross-referencing, if you go to the credibility of the witness,
Okay, I'm
That's-
there.
25 pages in, that
Yes.
first paragraph that says, if there are conflicts in the testimony of different witnesses, it is your duty to reconcile them if you can.
Mhm.
For the law presumes that every witness has told the truth. But when you cannot reconcile the statements of different witnesses, then you must decide which witness or witnesses you believe and how important their testimony was. You do not have to accept, that basically that whole first paragraph for the credibility of the witnesses. But particularly the fact that the law presumes that witnesses are testifying truthfully if the jury can find them. If there are conflicts in the testimony of different witnesses, it is your duty to reconcile them if you can, for the law presumes that every witness has told the truth. Just because it's, one says witnesses and one says defendants, so I want to make clear that the defendant is a witness that also has the presumption that they are telling the truth.
Okay, so the language specifically that you wanna add is, I wanna make sure I have that clear.
If there are conflicts in the testimony of different witnesses, it is your duty to reconcile them if you can, for the law presumes that every witness has told the truth.
And then keep her credibility is determined by the same rules of credibility of other witnesses determined, so you just wanna add that one sentence?
Yes.
Alright, what's the state's position on that?
It's the pattern instruction, it's clear to me, I don't see a reason to change with the instructions from the AOC on that.
Well, it's kind of duplicitous, because, I'm telling them that she's determined by the same rule of credibility of other witnesses, and then this is the section on credibility of witnesses, and those
Well,
are the
then,
rules.
what we could do in the alternative would be in the credibility of a witness section, include a phrase that, you know, the credibility of the witnesses, the law presumes that every witness, including the defendant in this case, that would achieve the same goal. I just want to make clear that the law also presumes that Ms. Daniels is telling the truth, just as it does with all of the other witnesses.
What's the state's position on that?
Again, I don't know how that's not clear. She's a witness and specifically just tells the jury that they're to judge her by the same credibility as every other witness. Adding anything just like almost emphasizes to the jury that you should believe the defendant more than any other witness in the state's mind. That's not appropriate. So the charge is clear and it's the pattern charge, and I'm opposed to any change in that.
Your Honor, I disagree. I think that when we have referred to witnesses throughout this entire trial, and we have referred to the defendant throughout the entire trial, those sound like two separate parties. And so if the jury's not clear that even though she is the defendant, she also, under the law and under the instructions, is a witness that should be treated the same way as the other witnesses, then that's impairing her right to have a fair consideration by the jury.
Or can we just say that the defendant is a witness and without all this?
I mean, I think if
The
Adding
defendant
that,
having testified, defendant as a witness, having testified in her own behalf, her credibility is to be determined by the same rules that the credibility of other witnesses is determined, and you will have to give the defendant's testimony in this case such weight as you may think it is entitled.
that's, Your Honor, I guess my issue with that is that the language in those two sections are very different. The language between the general credibility of a witness and the assessing the defendant testimony is very different language. Give it whatever weight you think it deserves is very different than the law presumes that these people are telling the truth.
I'll come back to that one.
Your Honor, there also, we had talked a little bit a couple months ago about the Supreme Court denial of certiorari from Sotomayor regarding Tennessee's instructions on second-degree murder and voluntary manslaughter. Justice Sotomayor took the position that Tennessee's instructions for sequential considerations in regards to second-degree murder and voluntary manslaughter are unconstitutional. And that is because voluntary manslaughter actually has an extra element that is not in second-degree murder. And we should be moving down and reducing elements rather than adding them. As far as the order of consideration being sequential, I would ask that the court instruct the jury to consider second-degree murder and voluntary manslaughter together rather than sequentially, because voluntary manslaughter has that separate element that makes it different than second-degree murder, but it's an additional element, an additional finding that the jury would not be able to get to if they did not move past second degree. So I would just ask on the sequential consideration to consider those two together.
What's the state's position?
I don't, that opinion did not change the law in Tennessee. It was one justice's opinion who was in the minority. Until the law changes, I think it's clear that the way we charge this in Tennessee is first degree, second degree, and then voluntary manslaughter.
I mean, I get your point. I mean, it makes sense, but, you know, at this time, the law is what the law is. But I definitely get it, you know, it's an additional element, but the law, at this point, I have to follow what the law is currently. And so I note your objection because I get it's an additional element, and usually when it's a lesser included, it's one that goes, you know, it's a less element, but in this case, there is an additional element, and so it makes sense to me, but, you know, I have to follow what the law is currently, which they go in that order, so I'm gonna have to overrule that objection at this time.
Thank you, Your Honor. And then I would just note on page 39, there was a somewhat duplicative,
Which, one?
it was no outside communications, but on page 2, there's no independent research or discussions. I just wanted to note the duplication.
Okay.
And it's not an exact duplication, but it's very, very similar.
Okay. You have any objection to that being removed?
No, ma'am.
All right. All right, give me a second on that other one. I have to step off and do a little research.
Thank you, Your Honor.
All right. testifying, I'm gonna leave the defendant, testifying, I'm gonna leave the instruction the same. Because I don't wanna, I mean, the language, I feel like it's duplicitous. Put that in there twice because the defendant testified she's treated as a witness and the instructions say her credibility is determined by the same rules that the credibility of other witnesses is determined. And so the credibility of witnesses, there's a section titled that with everything that she's supposed to be given the same, weight as everyone else. So I'm gonna deny that request at this time.
And Your Honor will not consider even adding the language that you had suggested about saying, when she testifies, she's considered a witness.
I'm gonna leave it the same. All right, were there any other corrections? I gave you each a copy. Y'all wanna take a moment to look at that to make sure there's not anything else before we print them off?
If we could have a minute, please.
Okay, sure.
You guys are right. A little bit of overkill on these short breaks today. Jeez Louise.
Which section?
What was added to the criminal attempt?
That's a pattern instruction for criminal attempt. First degree murder with serious bodily injury. That's a pattern instruction.
Is it the pattern instruction for regular first degree?
There is two separate instructions. It's one for first degree murder, and then there's a separate instruction for criminal attempt, first degree murder with serious bodily injury.
Yes.
There's a separate
So-
instruction.
I guess my issue is that by we're adding language to the criminal attempt first degree murder that's not in the pattern instruction. This says the essential elements necessary to constitute first degree murder are. And then it goes into that paragraph that is not part of the pattern instruction.
I think that's what's, hold on. A.
That's telling the jury this is first degree murder, but it's different than the pattern given for first degree murder.
It's an attempt, so it said the defendant unlawfully killed the alleged victim, that the defendant acted intentionally. Oh, we forgot, and the killing was premeditated. One, let me make sure she read that. That's the instruction. That the essential elements necessary to constitute first degree murder are the defendant unlawfully kills the alleged victim. That's under the first degree murder. In count one, the defendant acted intentionally. That's there, and that the killing was premeditated.
Yes. But what I'm looking at on the instructions that you're giving for first degree murder says that the defendant acted intentionally. A person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim.
Right. And so, what's the additional language is not there?
It just is, I think it will be confusing to have two different definitions of first degree murder in the same.
The difference is that because it's criminal attempt first degree murder, there's a reference to milling, stately milling, and the fact that you can have the intent to,
Kill another person.
kill another person. And so I think that's why the additional language is there in criminal attempt first degree murder versus first degree murder. Because of the fact that you can get criminal attempt murder by just having the intent to kill someone, not necessarily the person who is allegedly indicted. So I think that's what the distinction is.
Okay. I just was concerned by the fact that we have two different definitions of first degree murder.
I think it's just different, because of that, in the pattern instructions, that language is there. And I think it's because of that law. And that's bracketed language, what I included, so it's not always included. But I included that because there's an issue about intent, whether she had the intent to kill, Miss Perry. So it's bracketed language, it's not necessarily required to be included in there, but I included that because, of the proof that came out.
Thank you, Ryan.
All right, you're welcome.
Would Your Honor consider, given the issues about the voluntary manslaughter and second degree murder, would you consider a sentence at the end of the first paragraph under second degree indicating with second degree, the jury should take it, or should consider whether a heat of passion was present at the time of the alleged killing? Putting that they should be considering that at that point in time as a way to address that issue?
This will be a pattern instruction, so do you have any case law to say that I can't do that?
Your Honor you are allowed to change instructions. We're allowed to draft instructions and put them forward for the court's approval. They just have to comport with the law. And as long as they comport with the law, the court is allowed discretion within the jury instructions.
Okay, what is it you're asking for again?
So because of this issue, that is a very new issue brought up by that denial of writ, with Sotomayor basically telling Tennessee Supreme Court, you need to fix this. It is currently unconstitutional. We have been told by the United States Supreme Court that our jury instruction framework is unconstitutional. This is a way to address that so that Ms. Daniels gets a fair consideration by this court when they're comparing second-degree murder and voluntary manslaughter. And especially in this kind of case when we're saying this is a voluntary manslaughter, that for them to not be allowed to move to that section because of the way that our jury instructions are ordered completely denies her right to a fair trial. So if we just added a sentence to say, this is the distinction between voluntary manslaughter and second-degree murder, is that voluntary manslaughter requires the killing result from a state of passion produced by adequate provocation from the alleged victim sufficient to lead a reasonable person to act in an irrational manner. Even if you just said, like the jury should consider whether a heat of passion was present during this alleged shooting. Here.
I think it's already saying that though, because, I mean, it's showing you distinction between both, and so,
Yes, but it's not telling them to consider voluntary manslaughter yet.
what's the state's position?
The law in Tennessee is that you charge first-degree murder, second-degree murder, and voluntary manslaughter. So if that changes, I think that's what the court should do.
And I get your point, Ms. Speaks, I do, I understand what you're saying, it's just, this is the law, and I have to follow what the law is, but I get your point.
And I'm not asking you to change the law. I'm asking you to provide some clarification to the jurors regarding this. And that's what these instructions are supposed to do. They're supposed to help guide them through this process. And when we have a situation to where second-degree murder and voluntary manslaughter are sequential, they don't move to that heat of passion according to the jury instructions. They don't move to that heat of passion until they completely acquit of second-degree murder. Then if you don't tell them, you need to take this into consideration here before you, if in the decision on whether or not to acquit on second degree and move down to voluntary manslaughter, then they don't get to the point that they are able to consider that as an element. That's asking them to do the cafeteria style that we're not allowed to do.
I mean, these are the parent instructions adopted by Supreme Court, and, at this point, I'm gonna deny the request. I get it, but I'm gonna deny the request, because these are what they have set out, what we're to use, so at this point, I'm gonna deny the request.
Given the fact that the jury instruction requests specifically are supposed to be in writing, would the court give me a moment just to draft a pleading so that I can file it, to have it in writing to make the record?
Yes.
Thank you. No, Your Honor, I will include in that written request my additional request for the language regarding the defendant and witness credibility.
But other than that, there's no, those objections, was there anything else?
Oh, the issue, did you take out the language of the not pleading not guilty?
Yes, I took that out. Did the state have any corrections?
Before the section on defendant testifying.
What's the state's position?
I thought that's generally given when the defendant doesn't testify. So I'm not sure what the purpose of it is if the defendant testifies.
What's the point?
Your Honor, it's to clarify the burden of proof. It is to make clear, and I'm checking the burden of proof section now. But being clear that that does not place a burden of proof on the defendant.
State has the burden of proving the defendant, the guilt of the defendant beyond a reasonable doubt, and this burden never shifts but remains on the state throughout the trial of the case. The defendant is not required to prove her innocence. So I think that's good. She doesn't have to prove anything.
Or if we wanted to leave the and plea, we could add a second, like a final sentence that says the defendant pleads not guilty to the offenses as charged.
What's the state's position on
Either one of those is.
I'd prefer the second.
that? The defendant,
Pleads not guilty to the offenses as charged in the indictment.
defendant pleads not guilty to the as charged, if it's, what if it's charged? in
To the
indictment?
offenses as charged in the indictment.
Okay.
And just semantically, I'd probably rather offenses charged rather than crime charged.
What you mean on the heading, offenses charged?
Yes.
What's the state's position?
Yeah, I can give it an answer. I mean, it's a crime. It's charged as a crime, and that's what this charge says. So I don't know why we would change that.
Offense is charged, crime, same thing. Offense is charged. So do you wanna keep the language about the plea?
If we could just add that final sentence, the defendant pleads not guilty to the offenses as charged in the indictment.
Okay, but the heading, you want?
If, yes, then we can
offenses
leave
charged.
it offenses charged and plea. And then it outlines the offenses and then gives the plea.
Okay. All right, so were there any other changes besides that? Before we make the copies? I noted your objection.
Thank you, Your Honor. I do have that, written request on the way.
Okay.
Mistake.
Okay. All right, we can get the jury in.
courtroom, Your Honor.
You may be seated.
Good morning.
Good morning. While we're ready to get back to work, it's now time for me to instruct you on the law. If you could pass them a copy of the instructions. Does anyone have a copy? State of Tennessee versus Latoshia Daniels, indictment number 2501253. Members of the jury, the evidence in this case has been completed and the arguments are soon to follow. Now it is my duty now to instruct you as to the law. The law applicable to this case is stated in these instructions. It is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out any one or more of them to the exclusion of another or others, but should consider each one in light of and in harmony with the others. You are the exclusive judges of the facts in this case. Also, you are the exclusive judges of the law under the direction of the court. You should apply the law to the facts in deciding this case. You should consider all of the evidence in the light of your own observations and experience in life. Offenses charged and plea. The defendant, Latoshia Daniels, is charged in count 1 of the indictment with the crime of murder first degree. The offense necessarily includes the lesser offenses of murder second degree, voluntary manslaughter, reckless homicide, and criminally negligent homicide. The defendant, Latoshia Daniels, is charged in count 2 of the indictment with the crime of criminal attempt murder first degree. The offense necessarily includes the lesser offenses of criminal attempt murder second degree, criminal attempt voluntary manslaughter, and reckless endangerment. The defendant, Latoshia Daniels, is charged in count 3 of the indictment with the crime of employing a firearm during a felony. The offense necessarily includes the lesser offense of possessing a firearm during a felony. The defendant pleads not guilty to the offenses as charged in the indictment. The law makes it the duty of the court to give in charge to the jury the law relative to the case on trial, and the duty of the jury to carefully consider all of the evidence delivered to them on the trial and under the law given them by the court, render their verdict with absolute impartiality. No independent research or discussion. You as jurors must decide this case based solely on the evidence presented here within the 4 walls of this courtroom. This means that during the trial, you must not conduct any independent research about this case, the matters in the case, and the individuals involved in the case. In other words, you should not consult dictionaries or reference materials, search the internet, websites, blogs, or use any other electronic tools to obtain information about this case or to help you decide the case. Please do not try to find out information from any source outside the confines of this courtroom. Until you retire to deliberate, you may not discuss this case with anyone, even your fellow jurors. After you retire to deliberate, you may begin discussing the case with your fellow jurors, but you cannot discuss the case with anyone else until you have returned a verdict and the case is at an end. I hope that for all of you, this case is interesting and noteworthy. I know that many of you use cell phones, the internet, and other tools of technology. You also must not talk to anyone about this case or use these tools to communicate electronically with anyone about the case. This includes your family and friends. During your deliberations, You must not communicate with or provide any information to anyone by any means about this case outside the jury deliberation room. You may not use any electronic device or media, such as telephone, cell phone, smartphone, iPhone, or computer, the internet, any internet service, or any text or instant messaging service, or any internet chat room, blog, or website, including but not limited to Facebook, LinkedIn, YouTube, Snapchat, Instagram, Google, Twitter, or any other social media to communicate to anyone any information about this case or to conduct any research about this case until you have returned your verdict and the trial has concluded. No sympathy or prejudice by the jury. You can have no prejudice or sympathy or allow anything but the law and the evidence to have any influence upon your verdict. You must render your verdict with absolute fairness and impartiality as you think justice and truth dictate. Notes. Members of the jury, you have been allowed to take notes in this case. The court charges you that these notes are for your individual use only, and you should not use said notes directly or indirectly to persuade other jurors as to the accuracy of said notes. They should not be shown to others, nor compared, nor referred to in any way as authority, but should be used privately only by the maker of said notes as an aid to his or her individual memory. Indictment. The indictment in this case is the formal written accusation charging the defendant with these crimes. It is not evidence against the defendant and does not create any inference of guilt. Statements and rulings of the court. At times during the trial, I have ruled upon the admissibility of evidence. You must not concern yourself with these rulings. Neither by such rulings, these instructions, nor any other remarks which I have made do I mean to indicate any opinion as to the facts or as to what your verdict should be. Statements and arguments of counsel. Statements, arguments, and remarks of counsel are intended to help you in understanding the evidence and applying the law, but they are not evidence. If any statements were made that you believe are not supported by the evidence, you should disregard them. The court will now explain to you the law applicable to count 1 of this indictment, murder first degree premeditated killing. Any person who commits the offense of first degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, Brodes Perry, and 2, that the defendant acted intentionally. A person acts intentionally when it's the person's conscious objective or desire to cause the death of the alleged victim.
Hey, Lindsay.
And 3,
Good
that
to
the
see
killing
you.
was premeditated. Intentionally means that a person acts intentionally when it's the person's conscious objective or desire to cause the death of the alleged victim. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exists in the mind of the accused for any definite period of time. The mental state of the accused at the time she allegedly decided to kill must be carefully considered in order to determine whether the accused was sufficiently free from excitement and passion as to be capable of premeditation. If the design to kill was formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found if the decision to kill is first formed during the heat of passion, but the accused commits the crime after the passion has subsided. Second-degree murder, knowing killing of another. Any person who commits second-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, Brodes Perry, and 2, that the defendant acted knowingly. Knowingly means that a person acts with an awareness that her conduct is reasonably certain to cause the death of the alleged victim. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally when it's the person's conscious objective or desire to cause the death of the alleged victim. A defendant's conscious objective need not be to kill a specific victim. If you find beyond a reasonable doubt that the defendant intended to cause result the death of a person, then the killing of another, even if not the intended victim, would be second-degree murder. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation from the alleged victim, sufficient to lead a reasonable person to act in a rational manner. Voluntary manslaughter. Any person who commits voluntary manslaughter is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, Brodes Perry, and 2, that the defendant acted intentionally or knowingly, and 3, that the killing resulted from a state of passion produced by adequate provocation from the alleged victim sufficient to lead a reasonable person to act in an irrational manner. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation from the alleged victim sufficient to lead a reasonable person to act in an irrational manner. Passion means any of the human emotions known as anger, rage, sudden resentment, terror, or similar emotions which renders the mind incapable of cool reflection. Intentionally and knowingly have previously been defined in these instructions. Reckless homicide. Any person who commits the offense of reckless homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant killed the alleged victim, Brodes Perry, and 2, that the defendant acted recklessly. Recklessly means that a person acts recklessly when the person is aware of but consciously disregards a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and a degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of recklessly is also established if it is shown that the defendant acted intentionally or knowingly. Intentionally and knowingly have previously been defined in these instructions. Criminally negligent homicide. Any person who commits criminally negligent homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant's conduct resulted in the death of the alleged victim, Brodes Perry, and 2, that the defendant acted with criminal negligence. Criminal negligence means that a person acts with criminal negligence when the person ought to be aware of a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that the failure to perceive it constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of criminal negligence is also established if it is shown that the defendant acted intentionally, knowingly, or recklessly. Intentionally, knowingly, and recklessly have previously been defined in these instructions. If you find beyond a reasonable doubt that the defendant was criminally negligent, you must also find that the death of the alleged victim was the proximate result of the defendant's criminal negligence. The defendant's actions need not be the sole or immediate cause of death. If you find that the direct cause of death was an act of the victim, before you can convict the defendant, you must also find beyond a reasonable doubt that the act of the victim causing the death was a natural and probable result of the defendant's criminal negligence. The court will now explain to you the law applicable to count 2, criminal attempt first-degree murder charged in this indictment. Criminal attempt first-degree murder. Any person who attempts to commit first-degree murder where the victim suffers serious bodily injury is guilty of a crime. For you to find a person guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant intended to commit the offense of first-degree murder against alleged victim Tabitha Perry, and 2B, that the defendant did some act intending to cause an essential element of first-degree murder to occur, and at the time believed the act would cause the element to occur without further action on the defendant's part, and 3, that the alleged victim Tabitha Perry suffered serious bodily injury. New and known means that a person acts knowingly with respect to the conduct or to circumstance surrounding the conduct when the person is aware of the nature of the conduct or that the circumstance exists. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. Intent means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. The essential elements necessary to constitute first-degree murder are: 1, that the defendant unlawfully killed the alleged victim, and 2, that the defendant acted intentionally. A person acts intentionally when it's the person's conscious objective or desire to cause the death of the alleged victim. A defendant's conscious objective need not be to kill a specific victim. If you find beyond a reasonable doubt that the defendant intended to cause the result, the death of a person, and that she did so with premeditation, then the killing of another, even if not the intended victim, would be first-degree murder. And 3, that the killing was premeditated. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exists in the mind of the accused for any definite period of time. The mental state of the accused at the time she allegedly decided to kill must be carefully considered in order to determine whether the accused was sufficiently free from excitement and passion as to be capable of premeditation. If the design to kill was formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found if the decision to kill is first formed during the heat of passion, but the accused commits the act after the passion has subsided. Serious bodily injury means bodily injury that involves a substantial risk of death, protracted unconsciousness, extreme physical pain, protracted or obvious disfigurement, or protracted loss or substantial impairment of a bodily function of a bodily member, organ, or mental faculty. Bodily injury includes a cut, abrasion, bruise, burn, or disfigurement, and physical pain or temporary illness or impairment of the function of a bodily member, organ, or mental faculty. Criminal attempt, second-degree murder. Any person who attempts to commit a criminal offense is guilty of a crime. For you to find a person guilty of criminal attempt, the state must have proved beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant intended to commit the specific offense of second-degree murder, and 2b, that the defendant did some act intended to cause an essential element of second-degree murder to occur, and at the time believed the act would cause the element to occur without further action on the defendant's part. Intended, intending, intent has previously been defined in these instructions. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. The essential elements necessary to constitute second-degree murder have previously been defined in these instructions. Criminal attempt, voluntary manslaughter. Any person who attempts to commit a criminal offense is guilty of a crime. For you to find a person guilty of criminal attempt, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant intended to commit the specific offense of voluntary manslaughter, and 2b, that the defendant did some act intended to cause an essential element of voluntary manslaughter to occur, and at the time believed the act would cause the element to occur without further action on the defendant's part. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. Intended, intending, intent have previously been defined in these instructions. The essential elements necessary to constitute voluntary manslaughter have previously been defined in these instructions. Reckless endangerment. Any person who commits the offense of reckless endangerment is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proved beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant engaged in conduct which placed or might have placed another person in imminent danger of death or serious bodily injury, and 2, that the defendant acted recklessly. For the threat of death or serious bodily injury to be imminent, the person must be placed in a reasonable probability of danger as opposed to a mere possibility of danger. Before you can convict the defendant, the state must show beyond a reasonable doubt that a person or class of persons was in a zone of danger. The zone of danger is that area in which reasonable probability exists that the defendant's conduct will place others in imminent danger of death or serious bodily injury. Serious bodily injury means bodily injury that involves a substantial risk of death, protracted unconsciousness, extreme physical pain, protracted or obvious disfigurement, or protracted loss or substantial impairment of a function of a bodily member, organ, or mental faculty. Bodily injury includes a cut, abrasion, bruise, burn, or disfigurement, and physical pain or temporary illness or impairment of the function of a bodily member, organ, or mental faculty. The requirement of recklessly is also established if it is shown that the defendant acted intentionally or knowingly. Recklessly, intentionally, and knowingly have previously been defined in these instructions. The court will now explain to you the law applicable to count 3, employing a firearm during a felony charged in this indictment. Employing a firearm during the commission of a dangerous offense. Any person who employs a firearm during the commission of a dangerous offense is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant employed a firearm, and 2, that the employment was during the commission of or attempt to commit criminal attempt first-degree murder against alleged victim Tabitha Perry, and that the defendant acted intentionally, knowingly, or recklessly. Employ means make use of. Firearm means any weapon designed, made, or adapted to expel a projectile by the action of an explosive or any device readily convertible to their use. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it's the person's conscious objective or desire to engage in the conduct or cause a result. Knowingly means that a person acts knowingly with respect to the conduct or to the circumstance surrounding the conduct when the person is aware of the nature of the conduct or that the circumstance exists. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause a result. Recklessly means that a person acts recklessly when the person is aware of but consciously disregards a substantial and justifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of recklessly is also established if it is shown that the defendant acted intentionally or knowingly. The court instructs you that as to count 3, the term dangerous felony is limited to criminal attempt first-degree murder, criminal attempt second-degree murder, and criminal attempt voluntary manslaughter. Furthermore, the court instructs you that a defendant may not be found guilty of this offense unless you find she is also guilty of criminal attempt first-degree murder, criminal attempt second-degree murder, or criminal attempt voluntary manslaughter against the victim Tabitha Perry. The essential elements of criminal attempt first-degree murder, criminal attempt second-degree murder, and criminal attempt voluntary manslaughter have previously been defined in these instructions. Unlawful possession of a firearm with intent to go armed during the commission of or attempt to commit a dangerous offense. Any person who possesses a firearm during the commission of a dangerous offense is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant possessed a firearm, and 2, that the possession was with the intent to go armed during the commission of or attempt to commit criminal attempt first-degree murder, and 3, that the defendant acted intentionally, knowingly, or recklessly. Intentionally, knowingly, recklessly, intent, and firearm have previously been defined in these instructions. Possession may be actual or constructive. A person who knowingly had direct physical control over an object at a given time is then in actual possession of it. A person who, although not in actual possession, knowingly had both the power and intention at any given time to exercise dominion and control over an object is then in constructive possession of it. Possession may also be sole or joint. If a person has actual or constructive possession of the thing, possession is sole. If 2 or more persons have actual or constructive possession of a thing, then possession is joint. The court instructs you that as to count 3, the term dangerous felony is limited to criminal attempt first-degree murder, criminal attempt second-degree murder, and criminal attempt voluntary manslaughter. Furthermore, the court instructs you that the defendant may not be found guilty of this offense unless you find she is also guilty of criminal attempt first-degree murder, criminal attempt second-degree murder, or criminal attempt voluntary manslaughter against the victim, Tabitha Perry. The essential elements of criminal attempt first-degree murder, criminal attempt second-degree murder, and criminal attempt voluntary manslaughter have previously been defined in these instructions. Presumption of innocence. You enter upon this investigation with the presumption that the defendant is not guilty of any crime, and that this presumption stands as a witness for her until it is rebutted and overturned by competent and credible proof. It is therefore incumbent upon the state, before you can convict a defendant, to establish to your satisfaction beyond a reasonable doubt that the crime charged in the indictment has been committed, that the same was committed within the county of Shelby and state of Tennessee before the finding of this indictment, and that the defendant at the bar committed the crime in such manner that would make her guilty under the law heretofore defined and explained to you. The law presumes that the defendant is innocent of the charge against her. This presumption remains with the defendant throughout every stage of the trial, and it is not overcome unless from all the evidence in the case you are convinced beyond a reasonable doubt that the defendant is guilty. Burden of proof general. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden never shifts but remains on the state throughout the trial of the case. The defendant is not required to prove her innocence. Reasonable doubt. Reasonable doubt is that doubt created by an investigation of all the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required, and this certainty is required as to every element of proof necessary to constitute the offense. Burden of proof, elements and date of offense. The state must have proven beyond a reasonable doubt all the elements of the crime charged and that it was committed before the finding and returning of the indictment in this case. Impeachment of witness. A witness may be impeached by proving that he or she has made some material statements out of court which are at variance with the witness's evidence on the stand. However, proof of such prior inconsistent statements may be considered by you only for the purpose of testing the witness's credibility and not as substantive evidence of the truth of the matter asserted in such out-of-court statements. Excuse me. Further, a witness may be impeached by a careful cross-examination involving the witness in contradictory, unreasonable, and improbable statements. However, immaterial discrepancies or differences in the statements of witnesses do not affect their credibility unless it plainly appears that some witness has testified falsely. When a witness is thus impeached, the jury has the right to disregard his or her evidence and treat it as untrue, except where it is corroborated by other credible testimony about the facts and circumstances proved on the trial. Credibility of witnesses. You should consider all the evidence presented in this case by the state and by the defendant and give it a full, fair, and impartial consideration. Part of your responsibility is to determine what the facts are, based on what you heard from the witnesses. If there are conflicts in the testimony of different witnesses, it is your duty to reconcile them if you can, for the law presumes that every witness has told the truth. But when you cannot reconcile the statements of different witnesses, then you must decide which witness or witnesses you believe and how important his or her testimony was. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In forming your opinion as to which witness you believe, you may consider the following factors. 1. How the witness looked, acted, and whether the witness appeared to be telling the truth when he or she testified. 2. Whether the witness was in a position to know about the manner to which he or she testified. In other words, how well could the witness see or hear what he or she testified he or she saw or heard. 3. Whether the witness's statements were consistent and how believable the statements were. 4. Whether the witness had a motive to testify truthfully or to testify untruthfully. And 5. Any proof presented of the witness's reputation for telling the truth. Another factor for you to consider in evaluating a witness's testimony is whether the witness's testimony during cross-examination appeared to be contradictory, unreasonable, and improbable. However, immaterial or minor discrepancies or differences should not affect the believability of a witness unless it plainly appear that the witness has willfully testified falsely. In forming your opinion as to the credibility of a witness, you may look to the proof, if any, of his or her general character, the evidence, if any, of the witness's reputation for truth and veracity, the intelligence and respectability of the witness, his or her interest or lack of interest in the outcome of the trial, his or her feelings, his or her apparent fairness or bias, his or her means of knowledge, the reasonableness of his or her statements, his or her appearance and demeanor while testifying, his or her contradictory statements as to material matters, if any are shown and all the evidence in the case tending to corroborate or contradict him or her. Expert witness. During the trial, you heard the expert testimony of Erica Curry, a forensic pathologist. Dr. Amanda R. Bidding, during the trial, you heard the expert testimony of Erica Curry, in forensic pathology, Dr. Amanda R. Bidding, PhD, in forensic and clinical psychology, and Special Agent Brock Sane in firearms identification. All were who were described to us as experts in their fields. The rules of evidence provide that if scientific, technical, or other specialized knowledge might assist the jury in understanding the evidence or in determining a fact in issue, a witness qualified as an expert by reason of special knowledge, skill, or experience may testify and state his or her opinions concerning such matters and give reasons for his or her testimony. Merely because an expert witness has expressed an opinion does not mean, however, that you are bound to accept this opinion. The same as with any other witness. It is up to you to decide whether you believe this testimony and choose to rely upon it. Part of that decision will depend on your judgment about whether the witness's background or training and experience is sufficient for the witness to give the expert opinion that you heard. You must also decide whether the witness's opinions were based on sound reasons, judgment, and information. You are to give the testimony of an expert witness such weight and value as you think it deserves, along with all the other evidence in the case. Identification. The court charges you that the identity of the defendant must be proven in the case on the part of the state to your satisfaction beyond a reasonable doubt. In other words, the burden of proof is on the state to show that the defendant now on trial before you is the identical person who committed the alleged crime with which she is charged. In considering the identity of a person, the jury may take into consideration all the facts and circumstances in the case. The court further charged you that if you are satisfied from the whole proof in the case beyond a reasonable doubt that the defendant, Latoshia Daniels, committed the crime charged against her, and you are satisfied beyond a reasonable doubt that she has been identified as the person who committed the crime charged, then it would be your duty to convict her. On the other hand, if you are not satisfied with the identity from the proof, or you have a reasonable doubt as to whether she has been identified from the whole body of the proof in the case, then you should return a verdict of not guilty. Evidence, direct and circumstantial. One type of evidence is called direct evidence, and the other type is called circumstantial evidence. Direct evidence is those parts of the testimony admitted in court which refer to what happened and was testified to by witnesses who saw or heard what happened firsthand. If witnesses testify about what they themselves saw or heard or otherwise sensed, they presented direct evidence. Circumstantial evidence is all the testimony and exhibits which give you clues about what happened in an indirect way. It consists of all the evidence which is not direct evidence. Do not assume that direct evidence is always better than circumstantial evidence. According to our laws, Direct evidence is not necessarily better than circumstantial evidence. Either type of evidence can prove a fact if it is convincing enough. A defendant may be convicted on direct evidence, circumstantial evidence, or both. It is your duty to decide how much weight to give the direct and circumstantial evidence. The law makes no distinction between the weight that you should give to either one, or say that one is any better evidence than the other. You should consider all the evidence, both circumstantial, both direct and circumstantial, and give it whatever way you believe it deserves. Defendant testifying. The defendant having testified in her own behalf, her credibility is to be determined by the same rules that the credibility of other witnesses is determined, and you will give to the defendant's testimony in this case such weight as you may think it is entitled. Unanimous verdict. The verdict must present the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. It is your duty as jurors to consult with one another and to deliver with a view to reaching an agreement. If you can, do so without violence to an individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous, but do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. Unanimous means agreeing in opinion, being in complete accord, agreement of all jurors in holding one and the same opinion. Deliberation, order of consideration. In reaching your verdict, you shall first consider the offense charged in the indictment. If you unanimously find the defendant guilty of that offense beyond a reasonable doubt, you shall return a verdict of guilty for that offense. If you unanimously find the defendant not guilty of that offense, or you have a reasonable doubt of the defendant's guilt of that offense, you shall then proceed to consider whether or not the defendant is guilty of the next lesser included offense in order from greatest to least within that count. You should not proceed to consider any lesser included offense until you have first made a unanimous determination that the defendant is not guilty of the immediately preceding greater offense, or you unanimously have a reasonable doubt of the defendant's guilt of that offense. If you have a reasonable doubt of the guilt of the defendant as to all offenses charged and including that account, you should return a verdict of not guilty and proceed to the next count. The charged offense in count one of this indictment is first-degree murder. The lesser included offenses in order of consideration from greatest to least are second-degree murder, voluntary manslaughter, reckless homicide, criminally negligent homicide. Verdict form. If you find the defendant guilty of the charged offense beyond a reasonable doubt, your verdict should be, we the jury find the defendant guilty of first-degree murder as charged in count one in indictment 2501253. If you unanimously find the defendant not guilty of this offense or have a reasonable doubt of her guilt of this offense, you will next consider her guilt of lesser included offenses in order of their consideration from greatest to least as set out on the previous page. If you unanimously find the defendant guilty of lesser included offense beyond a reasonable doubt, if you unanimously find the defendant guilty of a lesser included offense beyond a reasonable doubt, your verdict should be, we the jury find the defendant guilty of blank as included in count one in indictment number 2501253. Insert instead blank the lesser included offense. If you have a reasonable doubt of the defendant's guilt of the offenses charged and included in the count, it is your duty to acquit her, and your verdict should be, we the jury find the defendant not guilty in count one of indictment number 2501253. You will write your verdict on the verdict form attached and sign one of your names to the verdict as foreperson. The charged offense in count two of this indictment is criminal attempt first-degree murder. The lesser included offenses in order of consideration from greatest to least are criminal attempt second-degree murder, criminal attempt voluntary manslaughter, reckless endangerment. If you find the defendant guilty of the charged offense beyond a reasonable doubt, your verdict should be, we the jury find the defendant guilty of criminal attempt first-degree murder as charged in count two in indictment number 2501253. If you unanimously find the defendant not guilty of this offense or have a reasonable doubt of her guilt to this offense, you will next consider her guilt of lesser included offense in order of their consideration from greatest to least, as set out on the previous page. If you unanimously find the defendant guilty of a lesser included offense beyond a reasonable doubt, their verdict should be, we the jury find the defendant guilty of blank as included in count 2 in indictment number 2501253. Insert in said blank the lesser included offense. If you have a reasonable doubt of the defendant's guilt of the offenses charged and included in the count, it is your duty to acquit her, and your verdict should be, we the jury find the defendant not guilty in count 2 of indictment number 2501253. You will write your verdict on the verdict form attached and sign one of your names to the verdict as foreperson. The charged offense in count 3 of this indictment is employing a firearm during a felony. The lesser included offense is possession of a firearm during a felony. Verdict form. If you find the defendant guilty of the charged offense beyond a reasonable doubt, your verdict should be, we the jury find the defendant guilty of employment of a firearm during a felony as charged in count 3 in indictment number 2501253. If you find the defendant guilty of this charge, you must identify the felony, either criminal attempt first degree murder checkbox, criminal attempt second degree murder, criminal attempt voluntary manslaughter checkbox. If you unanimously find the defendant not guilty of this offense or have a reasonable doubt of her guilt of this offense, you will next consider her guilt of the lesser included offenses in order of their consideration from greatest to least as set out on the previous page. If you unanimously find the defendant guilty of a lesser included offense beyond a reasonable doubt, your verdict should be, we the jury find the defendant guilty of blank as included in count 3 in indictment number 2501253. Insert in said blank the lesser included offense. If you find the defendant guilty of the lesser included offense, you must identify the felony, either criminal attempt first degree murder, criminal attempt second degree murder, or criminal attempt voluntary manslaughter. If you have a reasonable doubt of the defendant's guilt of the offenses charged and included in count 3, it is your duty to acquit her, and your verdict should be, we the jury find the defendant not guilty in count 2 of indictment number 2501253. You will write your verdict on the verdict form attached and sign one of your names to the verdict as foreperson. Selecting foreperson. When you retire to the jury room, you will first select one of your members as foreperson, who will preside over your deliberations. When you have reached a verdict, you return with it to this courtroom, and your foreperson will announce the appropriate verdict form to the court. Take the case, consider all the facts and circumstances fairly and impartially, and report to the court such verdict as truth dictates and justice demands. Signed, Judge Jennifer Fitzgerald, Criminal Court, Division 2. All right, so I have given you the law in this case. We're going to recess for lunch, and when we come back, you'll hear the attorney's closing arguments. And I have to remind you again, we're still not ready to discuss the case, okay? So I'm gonna excuse you for lunch. We'll come back, I guess at 1:45. I'm not sure if lunch too yet. We'll come back at 1:45. But I'm gonna excuse you for lunch, and we're still not ready to discuss the case.
Let's put your paperwork in your chairs, please.
may be seated. Welcome back. Hope you enjoyed lunch. We're ready to go forward with the closing arguments. State.
You broke my heart. I felt used. He broke up with me in a disappearing text message. Who does that to someone that they love? I wanted him to feel the pain that I felt. These are the words of the defendant, Latoshia Daniels. And earlier this week, we told you that you would hear a lot of testimony. You would see some pictures, you would see some videos, but most importantly, we wanted you to pay attention. And a key part of paying attention is not getting distracted, not getting confused as to who the victim is. The victims in this case are Mr. and Mrs. Perry, not the defendant. The decisions that she made caused them to be victims. And once we're finished here today, you'll see that this case really isn't that complicated. It's kind of easy. She's charged with 3 counts: first-degree murder, criminal attempt first-degree murder, and employing a firearm during the commission of a dangerous felony. First-degree murder, and you'll see this in your jury instructions, is defined as a premeditated killing of another. 1, the state has to prove that the defendant unlawfully killed a victim. 2, the defendant must have acted intentionally. 3, the killing must be premeditated. So, what is considered unlawful? Well, what is considered a lawful killing? One example can be the defense of others or yourself. Intentional. What does it mean to be intentional? Does it seem like an accident? Does it seem like a mistake? Your jury instructions say that something is intentional if it's a person's conscious objective or desire to cause the death of another person. Number 3, premeditation. The killing has to be premeditated. And as we learned in voir dire, premeditation doesn't have to be a specific length of time. It could be 2 seconds, 2 days, 2 weeks, 2 months. There's no time frame. It just means that you had to think about your actions and you had time to reflect. That could be as simple as stepping out of your car, raising your arm, and the time it takes you to point the firearm at someone and shoot and kill them. Or in this case, it could be driving to the gun store, purchasing a gun, purchasing ammunition, leaving the gun store, driving 3 hours to Memphis to your married ex-boyfriend's house, and knocking on their door. So this week, we started off hearing from Tabitha Perry. She testified that her husband was an executive pastor in Little Rock, and later he moved to Memphis along with her for a new position at Mississippi Boulevard, a prominent church here in Memphis. She also testified that they knew the defendant. They knew her from Little Rock when he was previously working over there. And on April 4th, 2019, Mrs. Perry heard a knock at her door. When she went to her door, the defendant was standing there. Now, she thought it was odd that Ms. Daniels was standing there, but she didn't think too much of it because they had given their address out to several people at the church in Little Rock. After she let her in, Mrs. Perry and the defendant sat and talked about 20 minutes until Brodes Perry showed up. When Mr. Perry showed up, the defendant even told you that they sat and talked for a while. She even took a drink. And once she decided that it was time to go, Mrs. Perry and Mr. Perry led her out of their doorway. And as Mrs. Perry was leading her out of the doorway, she turned back and she saw the defendant reach into her coat pocket, remove a gun, and shoot Mr. Perry in his own doorway. Once she did that, Mrs. Perry looked to her neighbors for help. She tried to get help, and then when she saw her husband lying on the ground, she went to go help him. She pleaded with the defendant, "Why are you doing this? Why is this happening? Please stop." Well, not only did the defendant not stop, she shot Mrs. Perry. And not only did she shoot Mrs. Perry, she reloaded her gun. After Mrs. Perry, we heard from Detective Roberts. He testified that the very weapon that was used to shoot Mr. and Mrs. Perry was purchased hours prior to this incident. He testified that the defendant purchased that firearm at a gun store at around 4:30 that same day in Sherman, Arkansas. Detective Roberts told us that he spoke to Ray Palladino, the general manager of that sporting goods store. From Mr. Palladino, he received the surveillance footage. And that surveillance footage showed the defendant coming in, purchasing a gun, purchasing ammunition, and leaving. Mr. Palladino also provided Detective Roberts with a receipt. That receipt had the defendant's first and last name on it. It had the serial number of the Ruger handgun that she purchased and the last 4 digits of her credit card. It's the same credit card that Detective Roberts discovered in the defendant's vehicle when he searched it. We also heard from Dr. Curry. Now, Dr. Curry testified that she performed Mr. Perry's autopsy. She testified that the cause of death was multiple gunshot wounds, and the manner of death was homicide. She testified to recovering the bullets, placing them in an envelope, initialing and dating them, and leaving them to be picked up. But Dr. Curry isn't the only doctor we heard from. Defense put on Dr. Bidding. Dr. Bidding was hired by the defendant and her team. And you heard her, she testified that she has testified for more defendants than she has prosecution. And ladies and gentlemen, think carefully about what she told you. She told you that depression and someone being suicidal does not mean that they cannot form the intent to kill someone. She also told you that she didn't even offer an opinion as to the defendant's mental state at the time of the offense. So what do we need? We need an unlawful killing, intent, premeditation. Unlawful killing. Well, there was no self-defense claim, and the only other firearm found in the residence, found in the crime scene, was in a box under a nightstand in a completely separate room. Intent. I wanted him to feel the pain that I felt. He broke my heart. You heard that from the defendant herself. Premeditation. We'll take your pick. Whether it's the drive to the gun store, the time it took to purchase, choose a firearm and ammunition, the time it took to drive 3 hours to Memphis to her ex-boyfriend's house, or the 20-minute conversation she had when she finally went up to their apartment. Criminal attempt first-degree murder. So in your jury instructions, you'll see what's on the screen right here. And that's a lot of words. But the judge is giving you the law, and the best way that I can describe it is that the defendant must have an intent to commit first-degree murder. But they fell short for some reason. The act wasn't complete. And that's how you have criminal attempt first-degree murder. We heard from Tabitha Perry, and she testified that she was shot in the shoulder. After the incident, she was transported to the hospital, and the doctors left the bullet inside of her. It wasn't until later that she had to get it surgically removed. It was causing her extreme pain. And by the time that she got it removed, it was poking out of her back. And even today, 6 years later, she is still suffering from pain from that incident. Now let's talk about transfer of intent. You heard in your jury instructions that sometimes when you intend to kill one person, and you don't kill that person, but you kill another person, that is how the transfer intent happens. Tabitha Perry testified that when she spoke to police, she told them that she didn't even believe that the defendant meant to hurt her. But that's okay. Because you don't have to actually hit your intended target to be charged and convicted of criminal attempt first-degree murder. As long as you had the intent to kill one person, it doesn't matter that you accidentally shot or you actually shot someone else. Your intent is still there. The only thing that's different is the person that got hurt. Employing a firearm during a dangerous felony. So on the screen here, it says that any person who employs a firearm during the commission of a dangerous felony is guilty of a crime. The state has to prove that 1, that the defendant employed a firearm. 2, the employment was during the commission of or attempt to commit criminal attempt first-degree murder against the alleged victim, Tabitha Perry. And 3, that the defendant acted intentionally, knowing, or recklessly. In addition to Mrs. Perry's testimony, we heard from Captain Draper, Officer McLean, and Special Agent Broxane. Draper testified that he and McLean were a few of the officers that responded to the crime scene on the offense day. And when he got there, he witnessed the defendant holding a firearm. She refused to comply with orders. Captain Draper testified to the non-lethal force that was used to unarm her. Officer McLean testified to securing and clearing the weapon that the defendant had in her possession. He noticed that there was nothing in the chamber, but yet there was a magazine in the gun. Special Agent Sane testified to the ballistics. He examined the Ruger, the casings, and the bullets from the medical examiner. He determined that all the cartridge cases and the bullets had been fired from that same handgun that was recovered off of the defendant. And now we're back at the beginning. You broke my heart. So I'm going to purchase a firearm. You broke my heart. So I'm going to purchase ammunition. You broke my heart. So I'm going to take that gun and the ammunition and drive 3 hours away to your home. You broke my heart. So I'm going to knock on your door. You broke my heart. I'm going to sit there and talk with you and your wife for about 20 minutes. You broke my heart. So I decided to leave. You broke my heart. So I'm going to shoot you and kill you in your doorway, and along the way shoot your wife. But it's okay, because you broke my heart. Decision after decision after decision. Ladies and gentlemen, if a broken heart was an excuse or a defense to murder, I wouldn't have a job. The standard of proof in this case is beyond a reasonable doubt. Not 100% certainty, not beyond all doubt, not beyond a shadow of a doubt. What's required is certainty that lets you rest easy at night. And now it's your turn. After you consider all of the evidence and apply the law that the judge has given you and use your common sense, the state is confident that your verdict will be guilty as charged. Don't let a broken heart distract you from the human life that was lost. Thank you.
Mayor, may we approach?
Yes.
Yeesh. Pretty good closing argument. Now let's see.
Anything but that the lawyer's statements are not evidence. And you can have no prejudice or sympathy, allow anything but the law and the evidence to have any influence upon your verdict. You must render your verdict with absolute fairness and impartiality as you think justice and truth dictate. So, we're gonna take a short recess and then we'll be back, for the next closing argument. So, and we're still not ready to discuss the case. Okay, so I'm gonna show you excuse for about 5 minutes and we'll come right back. A 5-minute recess.
Thank you. I'm gonna step down the restroom real quick before.
All right, you may see it. If you wish to make a closing statement.
Yes, Your Honor.
You have to see it.
Thank you. Good afternoon. We have told you from the very beginning that Ms. Daniels is not denying what happened. She is not saying, I have no responsibility. I have no accountability. That is not our position, and it has not been our position from the first time that we talked in Wood Island. We told you she is guilty of something, but she is not guilty of first-degree murder and criminal attempt first-degree murder and employing a firearm during felony. That is not what these facts illustrate, unless you're looking at them from far, far away and ignoring all of the details and all of the intent. When I was in high school, one of the formative trips that I took, my mom and I went to Barcelona, and we went to the Museum of Salvador Dali. This man had the most amazing brain. He could paint pictures that from far away looked like one thing, and then when you got close up on them, looked like something completely different. And I will never, ever forget standing in the top balcony of that museum, looking across the way and seeing this. And there's a little plaque that tells you, squint your eyes and look at it. What do you see? I saw Abraham Lincoln. I absolutely saw Abraham Lincoln. And then, when you walk back around, they tell you how to get up there. This is that painting close up. It's something completely different. Not only a different picture, but an entirely different emotional response. You would never think that that was the Abraham Lincoln that you had just seen. But that can be the difference between looking at something from far, far away and ignoring the details versus seeing the intricacies of what it is actually made of.
I want to talk to you first about Brodes Perry. We've heard a lot about him this week. He was a pastor at St. Mark Baptist Church in Little Rock. He was the leader of the life groups there. He was married to Tabitha Perry. This is what people standing far away saw. But when you got much more close, when you got to know Brodes Perry the way Latasha knew Brodes Perry, you started to see a different side. And sometimes even then, you miss it. He was a manipulative person. I know that he is not here anymore, and that is a tragedy. But that doesn't change the fact that during his time on earth, he manipulated the women in his life. He was controlling, and he wanted this lifestyle of ethical non-monogamy. Regarding the ethical non-monogamy, that was, when I talk about the manipulation of women in his life, that was a big source of it. He manipulated Tabitha into thinking, oh, well, this is just something that I thought about. It's okay that you don't want to do it. He manipulated Chriselle and Danielle, who he had the Marco Polo group with, in that he made this whole fiction where his wife was completely on board with this, and he was living this open, honest, and transparent lifestyle where he was ethically engaging in non-monogamy. As a pastor of the church looking for a group of people who would sanction his behavior, he found these women, educated women, and lied to them about this. He manipulated Latasha in so many ways. But regarding the ethical non-monogamy, his position was, my wife says it's okay, so my girlfriend should not be saying no. Even to Latasha, he lied about Tabitha being opposed to this lifestyle. When Latasha got involved, she thought Tabitha was on board with this ethical non-monogamy, and she was not. We heard from Brodes Perry
And
manipulating these women.
Those aren't an issue at home, but I get it, but it ain't an issue. I have been though, so if we talking, let's switch subject and get a little more serious. You know, for me, our agreements have been simple, right? No exes, nobody from Jacksonville, Florida, which is home for us, and nobody in the city that you live in, that currently live in, which means nobody in Memphis. That was the case, of course, in Little Rock, outside of Girlfriend, because Girlfriend is in Little Rock. The way that kind of happened is, short version, when she decided to open up the marriage and allow me to be on the other side of her. Girlfriend is a therapist, right? And she didn't go to her for therapy, but she asked her some questions. And based on this therapy session she had with this other lady. And she was asking her some questions after she had just said, bro, is this what I'm gonna let you do? Blah, 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 you know, it is what it is. Go from there, she asked her some questions. And so she was like, I just got a couple questions for you. And, you know, they were gonna play tennis together. She was one of the life group leaders. And so we had rapport, we had rapport. And she asked a question and it was like, yeah, blase, blase, I'm thinking about this. And what do you think about this? Or what do you think X, Y, and Z could potentially become? And I'm sorry, I'm looking to see who was in the cigar lounge because this is not what I really frequent that often. So I'm kind of careful about who potentially is in here because I don't want the last all pass. You know, I really want to go in and go chill in the back, but I'm not a member. But yeah, I'm trying to debate on what's going in here now. But anyway, so the next thing that she shared with her was, you, no, you know my husband like you, right? Well, he thinks you're attractive. And she was like, what? He's like, yeah, I know what he likes, and he thinks you're attractive. Not that he's been rude or anything like that. We've had conversations. Well, we did, because like one time we was sitting around having a watch. And she asked me, I was like, well, you gotta get her. I ain't gonna get her. I'm coming across with this creepy guy, right? We trying to spice things up. In that regard, even though that was even somewhat limited with the idea of somebody watching him, that's neither here nor there. But when the question came up, it was her, right there. The shit she asked, well, who would you want? And that was the first thing I said. She said, I know you like her. I know what. So anyway, so she said, like you know, blah, blah, blah. And she said, well, if you were interested, just, now I'm not saying that you are, but I'm also saying I've given him this X, Y, and Z, and he may come your way. And she did. Well, she said, okay, cool. So we had a conversation. And after that, that's when the whole nobody in the city thing came. But it was more like, I'll give you a pass with her because I essentially gave you the alley. But nobody. So I'm trying to figure this. So fast forward, I said a whole lot of shit, right? Trying to get the right. So I've been thinking about, the past couple weeks in terms of expanding, my ethical non-monogamy, and just kind of, so my wife, her and I, we were chatting over there. I was like, well, baby, I got a couple questions. I'm just curious, She knows about the, everything like that. So I was like, when do you want to know? When do you want to know that there's someone who has my interest or someone who I would like to pursue? Do you want to know the moment that I feel like it's more than just banter? Do you want to know at the moment that I would like to begin to banter? Do you want to know once I feel like it might be a thing beyond banter? Or what? Because this is kind of new for us, right? Because, girlfriend, Tasha, that's easy. That's been 2 years. That's been it for the most part. Outside of me going, that's how my birthday. But it's kind of been easy in that regard. So we're trying to figure out what does that look like. So I'm just kind of really thinking through where I am with that, right? Where in terms of those. So there's a lot of newness. I kind of said that just to say that there's still. I said that just to say that there's still a lot of newness even in this ethical non-monogamy that I'm wrestling with. And it's fun, right? It's fun, it's interesting, it's causing us to communicate and chat and really talk again about different things that we've kind of, in a real sense, have been settled to some degree. But realizing that in this ethical non-monogamy, we got to keep things in pencil and not pen. Some things are pen, right? There's some hard news, but gotta be flexible in terms of what that looks like. So that's why I know you talking about being sprung and giddy and all that stuff. I think because those flutters or those emotions, right, or those initial thoughts are all kind of new and very much new because this person is brand new. Like I don't know Cherie, right? I knew Tasha. That was different. There was some level of familiarity there. And that's typically how I've always engaged women, right? With some level of familiarity. I cannot, whether being in the same class again in terms of college or something like that, I've never kind of quote unquote cold called anyone. If that makes sense. Because I'm not, I don't think I'm that guy. So, yeah. Thanks for coming to my TED Talk. I don't know if I'm gonna go in here, but now I'm thinking how far would we go downtown? Because I'm like, there's a lot of folk in there. I don't know if I trust who's in that room right now. Shit. I just need to do better with smoking houses, cigar houses. I'm just, your opinion matters to me. Because we are in this relationship, but at the same time, like I said from the outset, I want to be respectful, but I also want to let you know that, your opinion matters. But at the same time, I don't want you to put me in a box, right? Because while we talked about it in theory, this is now the practice part. And with Tab being perfectly fine with, the situation, because how I've handled and been honest and transparent and open with her with regard to this current relationship, me expanding it is not an issue for me. Basically, she told me, hey, we can talk about it when you think it's worth talking about. But the way that you handle this, I'm fine with, and I trust your judgment because you haven't given me a reason not to. It's only 2 hours away, but yes, we were in Little Rock, so we were literally that, because it was at that point, wife was like, yeah, nobody at home. Like, this is an exception because I kind of threw you that, but no, you ain't dealing with nobody at home. Like, that was Jacksonville, so our heart knows that no Jacksonville, which is hometown for us, no exes, and no place in your current city. Those are the hard no's, right? She got an exception because it was there that she realized, well, yeah, I don't think I want him to be dealing with all these people, all these women, and no doubt these women would be in the church because that's all we do is kind of hang around, or in the community or close enough. So it was kind of one of those things. But
Those are clips from approximately 13 videos where he talks and talks and talks, and none of it is true. None of it. You heard Tabitha sitting on the stand saying, my hard no's were all of those things and then some. My hard no's were him seeing anyone outside of our marriage. But that's not what he told Rochelle. That's not what he told Danielle. That's not what he told Latasha. He created this world of lies, this alternate reality in this chat room where he got everything that he wanted. He got validation. He got to have this lifestyle where he was cheating on multiple women. And it was okay. It was okay that he, as a pastor, do those things. That's what those women gave him. And for Latasha, she gave him whatever he wanted. And Tabitha was his wife. He took and took and took from these women. And the whole time, he was lying to all of them. I want to talk to you about Latoshia Daniels. From far away, Latasha appears to be a professional, educated, well-rounded woman. She's a licensed clinical social worker and went into a profession to help people. Church member, active in the church, a life group leader, selected among the thousands of people in the church, and placed into a position of leadership by Brodes Perry. Did you notice in the one video, he said, what I typically do is engage with women from a position of familiarity. He knew how to attract the type of woman that he was looking for. And Latasha, when you got to know her and you got to see all of the details that make her up, she was exactly what he was looking for. She was so vulnerable because of the happiness being completely drained from her marriage, from the total lack of any emotional connection with her husband of 8 years. The traumatic history that she has had since a childhood, and always being told to keep a good face on. Her history of mental health, depression,
suicidal ideations, suicidal attempts. Her dependency on other people. He knew that when he got his claws in her, she would do anything to keep him with her, including keeping his secrets. He also knew that Latosha would have to keep his secrets because she had just as much to lose as he did. He had to have someone who was in a good job, with a good appearance, because if they found out about this affair with the pastor, she would lose everything. All of her clients, the life that she had built up in the church, her family's opinion, all of it would be gone. And he reminded her of that. From far away, their relationship, it wasn't a fair. It was absolutely wrong. And it was neither of them took Tabitha's feelings into consideration. Neither of them. And they should have. Tabitha did not deserve that. But especially at the beginning, if you looked at that relationship more closely, there was a lot of love there. Latosha built her life around this man. He liked bourbon, so she started learning bourbon. He liked cigars, so she started learning about cigars. She got him into running with her. They joined a biking club together. All of these things that they built. And this woman who came into this relationship so starved for love and affection was receiving it, finally. And she never wanted that to stop. But when you looked at it more closely, you could also see Brodes behaving in a very controlling way, in a very manipulative way. And Latosha was getting slung back and forth between these emotions of, oh, I love you. No, we're going to have some distance. This back and forth, pulling her heart in two pieces. And I will disagree with the state, because part of something that they have to prove beyond a reasonable doubt is intent. And one of the things that you have to look at is whether a heat of passion was present. And a broken heart definitely has to do with heat of passion. There is no emotion more powerful in this world than love. When she was with Brodes, Latosha was required to follow certain rules. Rule number 1 that she learned on day 1. You download the Confide app, you use it the way I tell you to, and you only communicate with me in this manner unless I tell you different. Rule number 2, when Brodes took trips, Latosha was expected to be there, and she had to pay her own way, whether she had the money to or not. Rule number 3, Latosha was not to call anybody to come to them. Even in the case of a medical emergency, she was supposed to call Pastor Pointer. He knew about their relationship. He would get Brodes help, and nobody would have to find out about Latosha. Rule number 4, Latosha was not to approach him in public. He was only to approach her, because she didn't have a way of knowing if he was with someone for the church or with another pastor that may not know about their relationship. Very strict rules on what and when she could say to him. Rule number 5, when she was in a hotel room on one of their trips, she was to remain naked.
Rule number 6. Towards the end of their relationship, Brodes added that that she should always respond to him with either yes, sir, or no, sir. And Latasha followed all of those rules because she loved that man. And she loved the love that she felt like she was getting. And then things changed. On March the 15th, Brodes behaved in a very different way. He treated her like a piece of trash, like someone who was there for his use, not his love, not worthy of his affection. And something in Latasha broke that day. And she decided that she was going to end her life. And yes, she did want him to feel that pain because it was so much pain in her. And she came and never once threatened him. There was never a single allegation that she put him in any danger or threatened him or ever even pointed the gun at him. She actually gave the gun to him once he talked to her for about 2 hours. Brodes knew what to say to make Latasha do what he wanted her to do. For good or for bad. And that day, he did get the gun from her. And he took the gun and kept it. She didn't see it after that day. Which brings us to April the 4th. Her gun, Brodes had put in a cigar locker in Little Rock. Latasha did not have access to that. She opened did her normal good morning text to Brodes. And finally, when he responded, our time has come to an end. And then it disappeared. And in that moment of disappearing, 2 years of a life, of a relationship, of love, was gone. And Latasha was still emotionally fragile from the traumatic experience on the 15th in March. Still suffering from those pains, but trying to work through it. And she decided that she was right the first time. She didn't need to be in this world. She couldn't be in this world. Not anymore. She had built her whole life around this man. And he broke up with her in a disappearing text. She apologized to her family and tried to make them understand that this is not something that she just thought about, that she's been struggling, and that the struggle was just too much. For this deeply religious woman to feel like God couldn't answer her prayers anymore because she was so deep down in this depression is just heart-wrenching. And that was at 3:14 p.m. on April the 4th. I'm having some technical difficulties. Okay. There we go. And so, after writing that suicide note, she did go to buy a gun. She didn't have one anymore, and she was going to kill herself. Yes, she planned to go buy a gun. That happened. She did not plan to go buy a gun to hurt anyone other than herself. She walked in, and you heard Mr. Palladino talk on the stand about the range of sizes and weights and prices. If you recall, when he talked about 9mm weapons, he said the cheapest 9mm weapons are in the 200s. He said that the gun that she chose is a small gun. The gun that she chose is a light gun. And when she went to that store on April the 4th, she checked out at approximately 4:47 after going through the background check and clearing it. And if you look, that gun cost $229. She bought the cheapest gun they had and just whatever ammunition they told her to get, because this was going to be the gun to take her life. So why spend a lot of money on it? After she left the gun store, she went back to her house. She did not want to stay there long because she was afraid her adult son would come home. Poured the bullets out on the bed, grabbed a handful, shoved him in her pocket, shoved the gun in her pocket, and left after leaving him as much money as she could leave him. I think it was $500. She got in her car and she started to drive. She was not driving to Memphis, Tennessee. She was driving to Jacksonville, Arkansas, to Johnson Park. This was a place that had particular significance to her because of various names associated with it. Brodes Perry was from Jacksonville, Florida. Her ex-husband's last name was Johnson, and her dad's name was Ray. All of those were men that had hurt her in her life, but that she had also loved immensely. She did not want to commit suicide at home. She did not want her adult son to find her, to have to go through that. She knew that her suicide would be hard on him, but she didn't want that weight on him. At that point in time, she believed her son would be better off without him. As she's on the way to Jacksonville, Arkansas, she looks up and sees a sign. And that sign said, "This way to Memphis." And Latosha thought to herself, if I can just see him one more time, I can find out why he is doing this, why he wants this to be over. Maybe I can change his mind. Maybe he will see that he still loves me. Maybe he will tell me that I am still worth loving. Maybe he will give me that reason to live. She drove to me. I want to ask, how many times have you been in your car running through thoughts in your brain as they race, and you analyze, and you're thinking, and all of a sudden you look up and you were like, how did I get here? I was on autopilot. This was not a cool, calm, do-do-do-do-do kind of drive. This woman was planning to commit suicide. This was not a drive to hurt anyone.
She wanted to talk to him, not to hurt him. And she did talk to him. She went to the Pocket, which is a cigar lounge in downtown. She knew that he goes there on Thursdays. His wife knew the same thing. It was a frequent place that he went, not just on Thursdays. And Latasha saw him and did as she was supposed to, walked past him until he acknowledged her. When he acknowledged her, they were allowed to engage, and she talked. They said that they sat there and talked for a long time, so long that the valet pulled the car away. And finally, by the end of the conversation, Brodes had said, look, we can be together if you're going to be okay with the ethical non-monogamy. And Latasha said, then I want us to tell Tabitha. And Brodes said, okay, we'll go tell Tabitha. You go to the apartment, talk to her about tennis, talk to her about, whatever. Tell her you're in town for a conference. We'll tell her together. And so Latasha goes to their apartment. It's unclear exactly what time she arrived at the apartment. It was somewhere between 9 and 10 o'clock, but either way, for the purposes of the timeline, we have that span that we don't have an exact time for. Some things we can get exact times for based on evidence, like that receipt, or if there's a phone call or something like that we can tie exact times to. We can't with this. Somewhere between 9 and 10 o'clock, Latasha indicated that she remembered the news came on. So fair assumption there, 9 or 10. And this was in Collierville. Tabitha answered the door, and Latasha came inside. They sat on that couch and talked for 10 to 20 minutes. At no point did Latasha ever raise a gun to Tabitha. At no point did Latasha ever threaten Tabitha. At no point did any indication that she was anything other than happy to be there happen. And then Brodes got home. And when Brodes got home, Tabitha described him as being very agitated when he saw Latasha. Did he think he called her bluff? That she wouldn't really go? He knew that she was having second thoughts. Did he really think that she was going to go into the apartment and tell Tabitha after 2 years? And she was there. And he was facing down the possibility of having to confess to his wife. And instead of doing that, he offered her bourbon. He talked to her about why she was in this why she was here for a conference. And Latasha, when he walks in, becomes confused and off balance because she thinks this big conversation is about to happen, and he's just making small talk. Even going so far as to say, well, if you're drinking, we probably need to clear those clothes off the guest bedroom. Latasha had never been there. And when she was there, Tabitha testified, and Latasha testified, that she didn't go into any of the bedrooms. She stayed in the main living area. That's a picture of the guest room. How would Latasha have known that there were clothes all over it? Unless Brodes said, we would have to take all those clothes off the bed. She and Tabitha and Brodes sat in that living room for 10 to 20 minutes, talking, with Latasha just waiting and waiting and waiting, thinking, well, he's talking about a bed. Maybe we're going to segue there. And he wasn't even making eye contact with her. At a certain point, he stopped even truly acknowledging her and just started talking to Tabitha. And Latasha realized he's not going to do it. He's not going to tell her. This doesn't mean enough to him. I don't mean enough to him. So I'm just going to go. I'm not going to bother y'all anymore. She does want to know why. Just as a practical matter, does it make any sense that she was sitting inside of an apartment with a closed door where no one could see in for about 20 to 40 minutes? If she was intending on killing them, why would she not have done it when they were sitting in there in private? Instead of after Tabitha walks out the door into opening it up into the outside. She is outside. Latasha's standing in the doorway. If this was a cool, calm, reflective judgment, why would she wait until that point in time? If this was the plan, why would she have not done it inside the apartment? Does that make sense? But instead of harming anyone inside of that apartment, Latasha got up to leave. And when she got up to leave, Tabitha went first and came out the door. And then Latasha was standing in the doorway, and Brodes was slightly behind her. Tabitha made it all the way down to the stairwell before she realized that Latasha and Brodes were not behind her. When she turned around, she saw Latasha pull out a gun and shoot Brodes. That happened. What she didn't see and what she didn't hear was the conversation that Latasha and Brodes were having at that door, where she said, "Walk me to my car. Be a gentleman. It's nighttime. Just walk me to my car." And Brodes just said, "Tabitha will do it." That emotional whiplash of being on the verge of killing herself to finding this hope that she can have the life that she has been trying to have with this man, to the disappointment of being dismissed by him, to this moment of just indifference, shattered her. Absolutely shattered her. And when she reached into her pocket to find her keys, she found her gun. And when she pulled her gun, that was not a calm and cool and reflected action. That was a heat of passion. She was so emotional in those moments. She did that act, but that was not a cool and calm act. That was a result of passion. As she's firing shots, she's yelling, "He broke my heart. He broke my heart." And when Tabitha starts trying to get close, Latasha tells her to stay back. And Tabitha, who is very confused in this situation at this point, dives in front of her husband and tries to shield his body with her body. And during that process, had a bullet hit her in the shoulder.
when she said, Latasha, you shot me. Latasha said, I didn't mean to shoot you. And Tabitha even told the police that she believed that Latasha was not trying to shoot her. Tabitha felt like all of this emotion was directed at Brodes, because it was. But it was a lot of emotion. Officers arrive on the scene at 22:36, military time, 10:36, non-military time. When the police arrive, Latasha still has the gun in her hand. Tabitha had told her, go, just go. They're coming. I can hear the sirens. Just go. And Latasha couldn't. She couldn't move. She couldn't move. And when the police were yelling at her, telling her to put down the gun, what they saw and what they described was her staring blankly and talking softly to herself and repeatedly putting the gun up to her head or up to her mouth or up to her chest and eventually crouching down on the ground. And Officer Dunlap testified that he would have noticed that that slide was back and that chamber was empty. He didn't see that. The circumstances when the police got there, they're trained to assess. And they have this thing called the use of force continuum that officers kind of make a judgment on. Do I need to put my hands on this person, soft hands? Or do I need to pull my sidearm and kill this person? And there are things in between. Do you believe that if the police thought that she was about to shoot the officers or Tabitha or Brodes in that moment, do you have any doubt that they would have shot the guns that they had trained on her? They opted for a non-lethal force because at that point in time, they deemed her a danger to herself. There is no part of what those officers saw that was cool and calm and reflective in Latoshia Daniels. They saw a woman in an emotional crisis. While the police were there, after Latasha was taken into custody, they called the EMTs who came and rendered aid to both Tabitha and Brodes. They were then taken to the hospital where they both underwent surgery. Tabitha, thankfully, was okay. Brodes was not. He did die as a result of these gunshot wounds. That has never been in dispute. There are several things that are not in dispute. It's just a difference of whether you look at it from far away or come in close to actually analyze it, to see the details that make it up. Tabitha came in to testify, and she talked to you about what she saw on April the 4th and what she experienced. And she was utterly confused by all of this because she had no idea what was going on. She had no idea why Latasha would be there because Brodes hadn't told her that he saw her earlier in the night. She had no idea that Brodes and Latasha had had a 2-year-long relationship.
that this woman was desperately in love with her husband. She had no idea. And that wasn't fair to her. That absolutely was not fair to her. But even Tabitha came forward to say that she didn't think that Latasha meant to shoot her. She also told y'all that she watched the clips that we watched before. She never said any of those things. She never had those conversations. She never had those conversations with Latasha. She didn't alley-oop him any woman. The hard nose for her was anyone. But he lied to his wife about that. And he lied to Latasha about that. He lied to Chriselle and Danielle about that. The police department then start their investigation. They took Tabitha's statement. Chriselle actually reached out to the police department to provide them these videos because she believed that Tabitha knew all of this. That this would be so helpful to them because obviously Tabitha knew everything and he was being so honest and transparent that they needed to have this information. Instead, they handed over evidence that showed that Brodes was manipulating all of these women. They collected the receipt. They collected the video surveillance from the gun store. They did a faraway view of what this was. And they looked at it and said, well, she bought a gun, she drove to Memphis, she went to Collierville, and she shot them. None of those facts are in dispute. Not a single one of them. But there's a lot more to it. There's a lot more to it. When she made that drive, she didn't go straight to Collierville. When she made that drive, she went downtown. Dr. Erica Curry came in and testified, talked about the gunshot wounds, trajectories, things like that. The fact that Brodes was shot multiple times is not in dispute. The fact that Latasha is the one who shot him is not in dispute. She is not coming here to tell you, I didn't do this. She's coming here to tell you that when I did this, I was so overcome by my emotions that I behaved in a way that I would not normally behave. I would note, with the autopsy, it does show no stippling, no muzzle imprint. What that means is that the barrel of the gun was 3 feet or more away. When Latasha was describing where everyone was sitting, and I believe Tabitha did too, Brodes was sitting directly next to Latasha. He was in the blue chair. She was on the end of the couch. She was within arm's reach of him. And nothing happened. The other doctor that testified was Dr. Bidding. She is both a clinical and a forensic psychologist. The difference in those two things are one can kind of look at your whole picture and gather information for a legal process, and the other one can gather your whole picture and look at it for a diagnosis process. She does both of those things. And she has a very impressive CV to go along with it. And when she met with Latasha, she did find a significant trauma history. She did not find malingering, which means no evidence of no evidence that Latasha was not being honest in her answers on these psychological tests. She actually found that she tended to underreport her symptoms, which was consistent with her history of always having to put on a good face. Dr. Bidding does not just blindly rely on what someone tells her. She listens to what someone tells her and then compares it to outside sources, especially for that legal process. And she did that here. And she found evidence to corroborate what Latoshia was telling her. She read the police reports, including narratives about Latoshia's appearance on the scene. She read Tabitha Perry's statement describing what had happened. She watched the video of Brodes Perry talking to Chriselle and Danielle about seeing Latoshia at the cigar bar that night before going home to Collierville. He read Latoshia's journals. She read Latoshia's journals. And all of those corroborated what Latoshia was telling her. She had a history of depression, and she would not, the state was right, she would not offer an opinion on her state of mind at the moment of the offense. And that's what matters legally, is at the moment. However, she did have a position about her mental state around the time of the offense. The reason that she could not speak to at the moment of the offense was because Latoshia has trouble remembering those moments, just like Tabitha did, because trauma can do that to your memory. Around the time of the offense, again, corroborating by all of those items of information, she believed that Latoshia was exhibiting depressive symptoms and emotional dysregulation. She was in turmoil. She told you sometimes people who truly want to die are hoping that someone will give them a reason to live. And that's what Latoshia was doing here. When she parked her car in downtown Memphis, she truly wanted to die. But she was hoping with every part of herself that Brodes would give her a reason to live. Latoshia talked to you, and she told you her story. From a young age, all the way up to reaching out to Brodes for counseling, through their relationship, about his rules, about her love, about the fact that he had told her that Tabitha was on board with this. He just hadn't told her yet about Latoshia. She told you about that emotional whiplash that she suffered for that last month leading up to April the 4th. She was getting pulled by her heart in so many different directions. And she talked to you about the fact that the moment that her hand went into her pocket was a moment when she was shattering. That was the word that she used. In that moment, she shattered. The timeline in the case supports what Latoshia told you happened. At 3:14, we have a suicide note written, which is before going to buy a gun. She then takes a quick trip home and then leaves for the park.
driving down 440, where there's a split for Memphis. She proceeds towards Memphis and arrives downtown, speaks with Brodes for a long time. Latasha then drives to Collierville, sits in the parking lot, calls Brodes, starts to have some second thoughts, and Brodes says, no, go on in. Go on in. Latasha goes to the apartment. Tabitha lets her in. They talk for 10 to 20 minutes. Brodes arrives back home. They talk for 10 to 20 minutes, and then Latasha says, I'm going to leave now. Police respond at 22:36, again, 10:36 Central Time. And by 10:36, Latasha is still standing there with the weapon in her hand. If she left Arkansas at 5 o'clock, and it only takes 3 hours to get to Collierville, why was it 10:36 when police arrived? Unless there was something that happened in between. And we know that there was something that happened in between because Brodes made a video saying, guess who I just saw as I'm walking out of the cigar lounge? All of that corroborates what Ms. Daniels came here to tell you. And I can tell you, sitting on that stand is not easy, especially talking about the things that she had to sit up there and talk about. She's not proud of what she did. She is extremely remorseful for what happened that day. When the prosecutor during cross-examination said, you went there to shoot him, didn't you? She said, no. No, ma'am, I loved him. I would never hurt him. No. That was not my intention. Because she didn't come to Memphis to hurt him. She was planning on hurting herself. And she walked into that apartment happy to be there in the hopes that she would get some semblance of that love back. Very briefly, I'm going to talk to you all about the law. You have your jury instructions, and there are some that I would like for you to cue in on because they're very important. If you remember during jury selection, we talked about criminal offenses and what's required. And what's required is an act and an intent. You have to have both. When you look at what are called lesser included offenses, the act never changes. The intent is what changes. On count 1, the lesser included offenses are all of the offenses: first-degree murder, second-degree murder, voluntary manslaughter, reckless homicide, criminally negligent homicide. As I told you, Latoshia Daniels pleads not guilty to first-degree murder. I submit that the appropriate charge in this case, as it pertains to Brodes Perry, is voluntary manslaughter. Voluntary manslaughter is an intentional and knowing killing that occurs during a heat of passion. That is exactly what the facts before us in this trial have laid out. Premeditation requires the exercise of reflection and judgment, careful consideration, sufficient freedom from excitement and passion so as to be capable of premeditation. When you are in that emotional state of passion, you can't reason properly. That's why premeditation requires the absence of all of those emotions to truly and thoughtfully judge and reflect on your actions before you take them. The emotions cloud that ability and impair that ability. A heat of passion means any of the human emotions known as anger, rage, sudden resentment, terror, or similar emotions which render the mind incapable of cold reflection. I submit to you, ladies and gentlemen, that that is exactly what we have here. This was a voluntary manslaughter. This was not a first-degree murder. And I told you from day one that Miss Daniels was not coming here to tell you I didn't do anything wrong. She knows what she did was wrong. She feels that every day. But that doesn't mean that that was a cool, premeditated act. Count 2, the count pertaining to Tabitha Perry, Archie. Criminal attempt first degree, criminal attempt second degree, criminal attempt voluntary manslaughter, and reckless endangerment. Those are the lesser included offenses as they pertain to her. I submit to you that the actions that led to Miss Perry's injury was reckless endangerment. The process that involved Miss Perry getting shot, she actually put herself into that line of fire, and Miss Daniels did not even mean to shoot her. Miss Perry even believes that Latasha was not trying to shoot her. Tabitha told the police that. Tabitha told y'all that. The police told you that. She tried to shield Brodes, and in the process she got hurt. And that was an unacceptable risk that Latasha took when she fired those shots. And she should have known that firing those shots in that apartment could have ended up hurting Tabitha. And that's exactly what happened. The definition of recklessly in your jury instructions is found on page 9. And that is where, when you look at reckless endangerment, it will refer you back to the other definitions. That's where you find recklessly. A person acts recklessly when they are aware of but consciously disregard a risk that is substantial and unjustifiable that the alleged victim will be killed. Because it's under the reckless homicide, they refer to actual killing. It's applicable also to the reckless endangerment without a killing. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under the circumstances as viewed from an accused person's standpoint. She had absolutely no intention to hurt Tabitha, but firing those shots was a risk that she would. And she did hurt Tabitha. I submit to you that the appropriate charge on count 2 is reckless endangerment. All of these must be proven by the state beyond a reasonable doubt. And we talked for a long time in voir dire about beyond a reasonable doubt. The prosecution must present evidence that is so convincing that it leaves no other logical explanation for the facts except that the accused is guilty of the charged offense to a moral certainty. One of the elements that must be proven is the intent, is Latoshia Daniels' intent. So if you come down and you have one version of this event where this is a cool, calm, premeditated murder, and you have another version of events where this is a woman who was in an emotional distress, and both of those are reasonable based on the evidence, then the state has not carried their burden as to first-degree murder. The appropriate charge would be voluntary manslaughter. And that burden is very, very high.
You can see both of those things if you step back and look at it and understand that while you may see two faces, you may see an apple core. And it's reasonable to see both of those things. No matter which one you looked up and immediately saw, or which one you prefer, both are reasonable as an explanation of what you see in that picture. This is the state's case. From far, far away, looking at these facts. Facts that are not in dispute. But they are missing the actual picture and showing you something that isn't really what this was. I'm asking you to look at all of the evidence that has been presented to you over the course of this week and to see the details of what that picture actually is. Thank you.
Any jurors right? State vote.
You've heard all the evidence and most of the arguments. And the assumption at this point, based on our history, is I'm not going to be up here for an hour and a half, right? And I thought about that yesterday and more today, and I hope you appreciate that. But I don't want you to take that to mean that I don't have anything to say about this case, or that I don't want you to understand how significant that the proof is on this case, because it's significant. And it's almost so clear that it just doesn't take a whole lot of time to explain it to you or to prove it to you. So if I can just take a few minutes to go back through there just to remind you of what we're looking at. The proof is clear even by her admission that she got a text that morning that said this relationship is over. I don't want to be in it anymore. And that shouldn't have been and probably wasn't a huge surprise to her. Because for the past months, weeks, she was even going to break up with him at one point. You know, really since he had moved from Little Rock, the relationship hadn't been the same. So what did she do in response to that? And she can tell you, this is what I plan to do. But the proof is she immediately went to buy a gun and immediately drove to Memphis to find him. 3 hours. And that's not disputed. She says, I was going to kill myself. But she wound up in Memphis with him. And she wound up at his house. She was still there when the police arrived. She shot him multiple times and shot Tabitha Perry Archie in the process. I mean, that's overwhelming proof of intentional premeditated murder, and she agrees all that happened. Do you remember there was a discussion, I believe it was in jury selection, about we do things different here than we do in the real world? I mean, I don't really know what that means. Because what we know is that in the real world, Brodes Perry is not here to tell his story. That he was shot and killed in his own home in front of his wife. And we know that Tabitha was shot while kneeling next to her husband, trying to protect him and help him and begging her to stop. You know, there's a lot of talk about reflection and judgment, and cool, calm, and collected. Well, she was cool, calm, and collected enough to say, according to her, Tabitha, get out of the way. She doesn't remember anything, but she knows she didn't mean to shoot Tabitha. I mean, that's in the real world. And this is hard, I know. Talking about Tabitha, it's a good time just to point out, I mean, there is transferred intent. And so we don't have to prove she was trying to kill Tabitha. Just that she was trying to kill somebody, and she was trying to kill somebody. She did kill somebody. And in that process, she shot and caused serious bodily injury to Miss Archie. So when you have a case like that, with those facts that line up perfect, I get the text, I go buy the gun, I drive to Memphis, I show up at his house and I shoot and kill him. You got to come up with something as a defense, right? So the defense is, I'm the victim. And I'm going to talk about that a little bit in a minute, but I want to talk to y'all a little bit about who she is, who is claiming that she's the victim in this case. It's an almost 40-year-old grown woman who has a doctorate degree, who has been twice married and twice divorced, who runs her own business, and who voluntarily entered into and started this affair with Brodes Perry. She admitted that. I liked the way he made me feel. I was wanting that kind of relationship at that time. She knew he was married. She had dinner with, she played tennis with his wife. She knew that Tabitha wasn't aware of this affair. You know, that there's rules. Brodes had rules. Well, I mean, one of the rules was we've got to talk to each other on this app that's not easily traceable. Is that a rule? Or is that what you would expect? Two people who were married because they were both married when this started, that they might come together and say, you know, we probably don't need to text each other and email each other on our phones and on our computers, because we got to hide this. Is that a rule? Is that manipulative? Can't go out in public with just the two of us because we don't want to be seen as a couple. Is that a rule? Or is that what you expect? When two people who are married decide they're going to have a sexual relationship and hide it from their spouse. Is that manipulative? Did she ever say anything about he forced me to be in this relationship? Did I miss something with that? Or did she say she liked it? She wanted it to be in that relationship. I can't put your plane tickets on my card. Is that a rule? Is that what you call that? You know, she couldn't make one trip, so she said, so I decided to go on the Jerusalem trip because I couldn't make it on the wherever the other trip was, Cuba or somewhere. So hey, I want to go on this other one because I didn't get to make that one. Is that you're expected to go? Or you want to go hang out with the married guy of my friend at a hotel room in Israel? Which is it? I don't want you to call 911 if there's like some kind of medical emergency. If you were staying in a hotel room with the person you're having an affair with, do you want her calling 911? How does that make Brodes Perry manipulative? She drank bourbon with him. She smoked cigars with him. She knew about his interest in this book. She read the book. She understood that he was interested in this non-monogamy lifestyle. She even tried to recruit one of her friends to help him out with that. A 38-year-old grown woman with a doctorate degree who run a business and has been twice married and twice divorced. You know, one of the things that happens when you kill somebody is there's only one side of the story that gets to be told, because there's only one person that's left alive. And so we spent a lot of time talking about how bad Brodes Perry was. We played videos for his widow and made her sit there and say, no, I didn't know that. He was lying to me. It seems illogical, but it's sometimes easier to feel sympathy toward the person who's still alive than it is the person who died. Because that's the only story you get. And she made terrible decisions. And you feel bad for her because she made those decisions. But they were her decisions. If Brodes was here, would he say, I'm sorry, I wish I hadn't done that way? We'll never know, will we? Did he make mistakes? I want to quote to you from the jury instructions because I think it's important. Because you can't look at her and say, I feel sorry for her because she made that decision. This is a quote. You can have no prejudice or sympathy or allow anything but the law and the evidence to have any influence upon your verdict. So feel sympathy toward her, but don't let that affect your verdict. You'd be inhuman not to feel sympathy toward her. But we talked about earlier, during jury selection, how sympathy and prejudice are not appropriate, and how you look at the facts, and if you determine that she intentionally, unlawfully, and premeditatedly killed him, it doesn't matter how sorry you feel for her. Because you're not supposed to use sympathy. Was Brodes honest? He lied to his wife. He lied to his church. He lied to two people in a book club on an app where they sent videos back and forth to each other who he had never met. You want to be married to Brodes? Maybe not. Did he lie to the defendant? I don't know if we know that. I mean, she knew he was married. She knew they were hiding the affair. She knew Tabitha didn't know. She knew about the book. She knew he wanted the non-monogamous lifestyle. She knew that early in the relationship. She read the book. What did he lie to her about? Probably more honest with her than he was anybody else. He may have lied to her. Lying and being immoral is not a capital offense. Latoshia Daniels also made a lot of choices. She got to tell you she's not proud of them. Brodes didn't. She made a choice to start the affair. She made a choice to continue the affair. She even made that choice after she claims that he made her feel bad in the hotel room to continue that affair. She made the choice to hide the affair. She chose to go purchase a gun after she got that text. She chose to drive from Little Rock to Memphis. She chose to go to the Perry's house. She chose to take her gun into their home. And you'll note that premeditation, if done prior to the act, so you can premeditate a murder, and then you can go to do that murder, and you can be overcome by adrenaline, excitement, any other emotion you can think of. But if you premeditated it before you do that, and then you follow through with the murder, that don't negate the planning that you did beforehand. Why didn't she shoot him when the door was closed? Think about it all you want to. It's probably hard to pull out a gun and shoot somebody, even if you plan to. You can plan that all the way from Little Rock to Memphis, and it still may be hard to pull the trigger. She made a decision to shoot and kill Brodes Perry, and she made a decision to shoot Tabitha. One of the defense witnesses was Dr. Bidding. What do we glean from her that's helpful? Because I don't doubt she was depressed, and that's what Dr. Bidding said, she was depressed. And I'm not taking that lightly. Depression is an awful disease that affects millions of people. But Dr. Bidding said it doesn't mean that you can't, Dr. Bidding said it doesn't mean that they commit violent acts because they're suffering from depression. Depression doesn't cause that, and depression doesn't cause you to lose your ability to plan, use judgment. And she specifically said that depression is not a cause of impulsivity. So if depression doesn't negate intent and premeditation, it doesn't keep her from being cool, calm, collective, it doesn't keep her from using reflection and judgment, is that helpful to us? You also heard from Dr. Bidding about this defense under Tennessee law called insanity. And what she said was, there's a defense in Tennessee. And if a person is of this mental state where you can't appreciate the wrongfulness of your actions, then they can be found not guilty of the crime, because there are two things, the act and the intent. And she said, this insanity applies when someone is not able to appreciate the wrongfulness of their actions because of their mental state. And I said, well, did you evaluate the defendant for the criteria for insanity? yes, it was not there. Insanity would not, the criteria were not met when I evaluated the defendant for that. You also heard Dr. Bidding talk about what she called diminished capacity, which in Tennessee is this: you might still be guilty of something, but you're not guilty of the more serious offense because your capacity is diminished because of your mental state. And again, I asked Dr. Bidding, a defense expert, a witness called by the defense. What about when you evaluated Latoshia Daniels for this diminished capacity? Didn't meet the criteria for that. Well, Dr. Bidding, the defense expert, what about post-traumatic stress disorder? Did she meet the criteria for that? No. No, she didn't meet the criteria for post-traumatic stress disorder. Dr. Bidding, the defense expert, does potentially wanting to harm herself, does that negate intention and premeditation? Can't say that it does negate intention and premeditation. Well, tell us, Dr. Bidding, about her mental state at the time she committed this offense. I'm unable to provide an opinion about her mental state at the time she committed this offense. What about Dr. Bidding's testimony did you find helpful? I found helpful the fact that she said she did appear to exercise judgment just prior to this homicide. And she did appear to engage in planning in the moments leading up to this homicide. So we've talked about she used judgment, had a cool, calm, and collected thought when she told Tabitha to get out of the way. I don't want to shoot you. Dr. Bidding says she has cool, calm, and collected thoughts all day, up to the moments before the homicide. Then we heard from Officer Duncan, who said he pointed, I saw her point the gun at herself. She was holding the gun. When I got to the door, I said, drop it. She pointed the gun at herself. At some point during that day, did she intend to harm herself? I don't doubt that. But I can tell you what she had at that moment. She had the judgment and reflection not to harm herself. She had the judgment and reflection not to point that weapon at the Collierville Police Department because they had a gun pointed at her. Where's the lack of judgment and reflection? Was she devastated? Was she in love? Were her feelings hurt? Had she spent 2 years in a relationship with a married man and she realized he wasn't going to leave his wife? I don't doubt that. Did she know what she was doing? Yes. And it's unfortunate. It's unfortunate for her. It's unfortunate for Brodes Perry's family. Unfortunate for the widow of Brodes Perry. That doesn't change what happened. did she plan this all the way from Little Rock? And I'm gonna change a little bit and talk about something different here, and I want to be very clear about what I mean when I'm doing this. I submit the proof shows that she did plan this from the time she got the text. But I want to talk about why I think that's not required. It's impossible to know what she was thinking because we can't read her mind. Was she planning to kill Brodes and herself? Maybe. That doesn't negate the fact that she killed Brodes and that she did it on purpose, intentionally, with premeditation. Did Brodes ask her to go to his house? I mean, his reaction says no. The history between the two of them says no. A hidden app. Got to have somebody with us. We went 2 years, we hadn't told her. He didn't want Tabitha to know. So the history between them indicates no. So the evidence is contrary to her description of what happened. And again, I'm going to emphasize that because I'm going to make another argument. But I want to read. The evidence is contrary to what she describes as happening. But it really doesn't matter. She's asking you to consider voluntary manslaughter. And the kind of the difference is the killing resulted from a state of passion produced by adequate provocation from the alleged victim, sufficient to lead a reasonable person to act in an irrational manner. Well, there's no question she acted in an irrational manner because it's hardly ever rational to point a gun and shoot a guy 7 times who's not threatening you, doesn't have a weapon, and is not even, there's not even a chance he's harming you physically. No even history of him harming you physically. So that's never a rational act. So the second part of that is very important because it can't be adequate provocation that makes Latoshia Daniels act in an irrational manner because she did. And all you would have to say is, yep, there was some provocation that made me act irrationally, so I'm not guilty of homicide. I'm not guilty of murder 1. It says sufficient to lead a reasonable person to act in an irrational manner. Did what happened to her, is that enough to make a reasonable person act that way? To point a loaded gun at an individual who's unarmed and not threatening you and pull the trigger not once, not twice, not 3 times, not 4 times, not 5 times, not 6 times, but 7 times. Somebody talked to you about the classic law school example of voluntary manslaughter, where someone comes home and they find their spouse in bed with somebody else having an affair. And before they have time to reflect on that or cool down, they kill either their spouse or the person they're having the affair with. And that is the classic law school example. Latoshia Daniels doesn't fit the classic law school example. Her spouse was not having an affair. She didn't react immediately to some huge thing like that. Somebody hit my child or whatever. She knew this relationship was coming to an end. And she knew about this affair for 2 years. And she knew Tabitha didn't know about it. So again, it's not voluntary manslaughter. So I want to look at her story and set aside all the other evidence for just a moment. Not conceding there's not all the other evidence, but I want to just set it aside for a minute. What was the adequate provocation? He wouldn't walk me to the door? To my car? It's the only provocation I heard. Because right before that, she was talking, and she even made a decision. I feel like I'm being played, was what her testimony was. I'm embarrassed. I want to leave. Is that a person overcome that doesn't know what they're doing? And she had known since that morning he was ready for this relationship to end. And she had known for months that the relationship was not what it had been. That's not provocation that would lead a reasonable person to act in an irrational manner. It may be provocation that would break your heart, that would hurt your feelings, that would cause you to be really upset and really mad and really regretful, maybe ashamed, maybe embarrassed. She told you why she did this. And to convict, all you got to do is listen to her. She told Brodes. I don't know if he heard her because he had a bullet in his head. You broke my heart. That's why she did it. The evidence suggests that she made the decision to kill him. Maybe herself that morning. But even if she made it when he declined to walk her to the car, it's first-degree murder. There's no time period required for premeditation. Some of the things you can look at, she shot an unarmed, unthreatening person. She was making decisions that she felt like she was being played. She was embarrassed. She was walking to the door. She reached in her pocket and pulled out the gun that she had brought into their home. She didn't go back out to her car to get the gun. Was it for protection from her car to the door, or did she forget it was there? We heard both sides of that story. And she shot him 7 times. And killed him. How can that not be intentional and premeditated? Even disregarding all the evidence except what she tells you. How can that not be intentional and premeditated? Especially considering Dr. Biding's testimony. And all the things she did. Tabitha, get out of the way. not pointing a gun at the police, not harming herself. Where was this total loss of judgment? She was hurt, she was mad, she was embarrassed. She didn't like what Brodes had done to her, what Brodes had done to her. I ask you to follow the law, follow the evidence to it. And if you do that, I submit you'll find that she's guilty as charged on all 3 counts of the indictment. Thank you.
All right, now it's time to select our alternates.
Wonder who their alternates will be.
All right, Mr. Lord and people will be our jury. I'm going to send you back with the instructions, the indictment, and the exhibits. I think except the firearm. The first thing you will need to do is select a 4-person. And when you have a verdict, you will write your verdict on the verdict form. I will review the form to make sure that it's in proper form, and then I will have the jury foreman read the verdict. So I'm going to show the people who are on the jury, excuse the alternates. If you could remain, you can finally discuss the case. So I'm going to show you excuse at this time.
Folks, are coming with you, bring your
She
paperwork
keeps
with you.
telling them each time, you still cannot discuss the case. Now they can finally discuss the case. What y'all think's gonna happen? What do you think's gonna happen? I wonder how long they'll deliberate, or will they go home early? They are an hour, they're on Central Time, so. Let's see.
How to relation disappearing text.
So they are currently discussing, they're just playing a lot of rerun stuff. So jury deliberations have been going on for 31 minutes and 39 seconds.
That she just thought about. He said that the gun that she chose is a
So,
small gun.
so.
The gun that she chose is a light gun.
Anybody want to come up and chit chat about this for a minute?
And when she
QB,
went to that
where you
store
at, man?
On April the 4th, she checked out at approximately 4:47.
QB,
After going through the
Morgana.
background check and clearing it. And if you look, that gun
Everybody's
cost
been quiet for the last little bit. Donnie, are you still asleep?
She bought the cheapest gun they had.
Excuse
and
me.
just whatever ammunition they told her to get. Because
Excuse
this
me.
was going to be the gun to take her life. So why spend a lot of money on it?
Bum, 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 ba-da-bum, bum.
After she left the gun store, she went back to her house.
I really, really, really like the defense attorney. A lot.
Would come home.
I like her a lot.
Pour the bullets out on the bed, grabbed
You
it
guys, my
from the
face is so hot right now. I'm like having a massive
and left after leaving him as much money as
flash.
she could leave him. I think it was $500.
massive.
She got in her car
massive, massive. And it's
She
like
was
my
not
ear is blood red.
driving to Memphis, Tennessee.
Compared to this
She was
side,
driving
it's
to
much
Jacksonville,
redder.
Arkansas, to Johnson
You
Park.
were sound asleep, Morgan. I have been sitting here working my fingers to the bone while listening.
Her ex-husband's last name was
I have not
Johnson.
stopped
Her
since
dad's
5:30
name
this morning.
was
I have
Ray.
worked nonstop since
All of those
5:30.
were men
Not
that had hurt
not
her in
stopped.
her life, but that she had also loved.
We need to take a break here, but first we have a programming note. High-profile attorney Alan Jackson, who represented Karen Reed, will join Vinnie Politan live for an in-depth interview.
Jackson is currently representing Frazier Bohm. Now, he's accused of driving more than 100 miles per hour through Malibu, California, and crashing into 4 sorority sisters, killing all of them.
Oh my
Gonna get the
God.
inside scoop on this trial right here on Court TV, Monday night at 9 on Vinnie Politan Investigates.
Lord have
We're going to
mercy.
take that break down. We'll get you back to more of the defense's closing argument in the Broke My Heart murder trial.
All right.
Focus on your phone.
So,
Speed to justice.
until I heard a little voice saying my name, Morgana. Morgana. I've been sitting here though listening and working, and while I was listening, listen to this. See if you can hear this difference. Okay, so you don't hear a fan now, but my fan is on low, but listen. Now it's on high. Can you all hear the fan now? Why is it doing that to me? It keeps saying I've lost connection to my mic. And then it like automatically mutes. What is up with that? Did y'all hear my fan when I had it on full blast? Yes. Okay. It feels so good. It feels so good, good, good. Yeah, that's true. She did say that earlier, Sherry. Morgana earlier in the chat today said, this part makes me want to go to sleep. This part's going to put me to sleep. And sure enough, it did. Sure enough, it did. You know what? Husband came home from work earlier and told me that we're supposed to get snow on Monday. Did you know that, Morgana? Already. I don't remember the last time we had snow this early. Like usually even at Christmas time, it's so warm the kids are playing outside without jackets on, you know? Crazy pants. That's what some of them are saying. Hey, Cherie. Oh my gosh, you guys. So today is Friday. Dale promised kiddo a milkshake from the Dairy Queen, right? So they went and got milkshakes after school. And he brought me another Butterfinger Blizzard. So here's the trick. I've told some of you this. But you know how, like, I don't like plain vanilla ice cream. Even if it's got, like, Butterfinger mixed in it, I'm like, meh, it's still just too plain Jane for me. So he tells them to put like some like peanut butter, pumps of peanut butter syrup or whatever into the soft serve too. So it makes it very peanut buttery ice cream. And oh my God, with the Reese's, or not the, I usually get Reese's, but I really prefer the Butterfinger now. So he brought one home for me and I inhaled it. And I have had to go to the bathroom twice since then. Like my belly got upset. She is the daddy's little girl. She is. Super duper daddy's little girl. Mother Nature doesn't have a clue what she is going to give us nowadays, right? Tennessee. I wonder how long they'll deliberate tonight. I don't know that they'll. I mean, I really don't see them going for very long if they're not close. I mean, I don't see them reaching a verdict at 40-some minutes in. But I also don't look for them to stay all night. They might stay a few hours and then see how close they are to coming to a unanimous decision. And then if they're not still close, then coming back on Monday. Okay, I'm out of something to drink. I've got a bottle of water over there.
The tactic of the defense, I think the tactic of the defense is give her something.
Morgana, tell me, what did you think of her testimony?
And look, I think both can be true. I think she can.
What did you think of her testimony?
Issues and simultaneously snap. or Michael, she can have all these mental health issues and still know what she's doing and want to have done what she did. So, both are possible. And if the jury says, you know what, it's a bridge too far, then they don't give her a lesser included charge. If they are sympathetic to her, if they look at
Morgana was sleeping, don't ask her. Oh, hey Patricia, let's be real. They don't want to go to work tomorrow. I bet they come back tomorrow. Got that alone.
But if it's a lesser
For
is it a potential jury nullification? Because I think the evidence
wait, what?
could conclude she's guilty. I question
Why would they be going to work tomorrow? Tomorrow's Saturday.
a sympathy factor because of what you just said.
So typically a manslaughter or lesser charge to murder is based on some kind of heated passion, heated moment, snapping. Those are
Oh, for that alone. I bet they come back tomorrow for that alone. You think they'll come back on Saturday?
manslaughter charge.
Tomorrow is Saturday, right? Am I crazy pants right now?
By the prosecutor that she had
Yeah, today's Friday.
to know and want to do what she
Do they come in on Saturdays?
She may not have gone over there with the intent to do what she did, but she certainly formulated that desire and then
Patricia said, oh my, it's been a long week. I forgot it was Friday. I was getting ready to say, if today's Thursday, I'm in big trouble. So, if today's Thursday, I am in, like, the Twilight Zone. I'm just letting you know. It'll be like Groundhog's Day, right?
Or the defense attorney's closing argument.
Lord have mercy. You need a break, Patricia. You need a break, ma'am. You guys, I'm so devastated. So, I went and had my nails done, right? Went and had my nails done a while back. They grew out. They got very, very long. And my pointer fingers were getting, like, lifting really bad. And what did I do? Instead of going and getting them redone, I peeled them off. So when I peeled those two off, I was like, okay, well then I'm just going to have to peel the rest of them off because I can't stand that. So then I went and I had some more fake press-ons. So I put my press-ons on and hadn't even had them on 24 hours and my pinky popped off. So, needless to say, I'm probably going to go in the morning and get my nails done again. This week feels never ending, so in my mind it was Thursday. I gotcha. I understand. It has been a long week, I will say that. It has been a long week.
I want to ask, how many times have you been in your car running through thoughts in your brain as they race, and you analyze, and you're thinking, and all of a sudden you look up,
I'm just wondering how long they're going to deliberate for.
how did I get here? I was on autopilot.
So now, Patricia, that you realize it's Friday, do you think that they'll work for a few hours and then call it a night and say, let's come back Monday?
This woman was planning to commit suicide.
Or do you think this is going to be a slam dunk one way or the other?
To hurt anyone.
That they're all going to be on the same page? This could be one, depending on how the jurors are feeling. Like if they're, even though they're not supposed to, but you know how that goes. Let's say somebody takes a personal, has a personal opinion on the matter based on something that's happened in their life. If they're going to vote, like be the swing vote. That's not the right word.
She was supposed to walk past him until he acknowledged
Like
her. When he acknowledged her, they were
the one that hangs the jury. You know what I mean?
They said that they sat there and talked for a long time.
Could be a hung jury.
And finally, by the end of the conversation, Brodes had said, look, we can be together if you're going to be okay with the ethical
I'm getting the yawns, Morgana. Look what you did.
that I want us to tell Tabitha.
Look what you did.
And Brodes said, okay,
With the defendant getting on the stand, a Kleenex box was needed. Oh, goodness, yeah. She was snotting and snorting and carrying on.
we'll tell her together.
You could tell those were real tears, right?
So Latoshia goes.
I don't know. For me personally, I feel bad for the woman. I feel bad for her. It sucks what she's been through.
It was somewhere between 9
You know?
and 10 o'clock.
Yeah, he's a dirty dog.
Either way, for
Um,
purposes of the timeline, we have that span that we don't have it.
But you still, like I said earlier, teenagers
On evidence, like,
handle breakups better than that.
if there's a phone call or something.
And they're raging with hormones.
We can't with this. Somewhere between 9 and 10 o'clock.
So.
Latasha indicated that she remembered the news came on. So, fair assumption there.
I don't know. I just can't wrap my mind around it. And I can't wrap my brain around the fact that she emptied out the firearm and reloaded it.
They sat on that couch and talked for 10 to 20 minutes.
I think she did it because she was done with the mental abuse from him. Probably.
Ever raise a gun?
Yeah, I think she was like, fine, if you're not going to do what you said you were going to do, then this is it.
At no point did any
And I kind of wonder if it was a situation where she was going to shoot him and then shoot herself and then chickened out, you know? Oh, and FYI, in case you missed it, I think it was not yesterday, it was the day before. We had talked about that Christopher Schultes guy, the dad of the 2-year-old little girl that he left in the hot car, you know? We talked about that a lot over here, but turns out they did say that it was that he had committed suicide for sure. So that was confirmed.
the possibility of having to.
I don't know how, but
And instead of doing
yep.
that, he offered her bourbon. He talked to her.
That's what bothers me, reloading. Right.
Here for a conference. And
Like when you stop and think about it,
off balance because
if you're planning to,
conversation is about to happen, and
if you're planning to just shoot yourself, right? If you're planning to do that, why do you need more than one cartridge? Like, why do you even need more than maybe 2 bullets, okay? Like, if you accidentally miss or whatever. But, so in my mind, that tells me for her to have another cartridge and in her pocket, that she was planning to shoot more than just herself. You know what I mean? That doesn't make any sense. Doesn't make any sense. I really liked what the defense attorney said, though, about the picture, the that art work that she thought was Abraham Lincoln, and how when you're looking at it up close versus when you're looking at it from a distance, it's 2 totally different things. I like how she likened that to the relationship between Latoshia and Brodes. I don't know. I really like her. I liked her a lot. She's a good defense attorney. Let's just see if what she said sticks. I personally don't think it will. I think she's going to get convicted. Unless they have a hung jury. I mean, honestly, I haven't seen all the evidence. I mean, I've heard, I've listened, I'm sure I've missed a lot of stuff. But based on what I've heard, I think I would have to say guilty. I would have to vote guilty. For me, it's the reloading, having an extra cartridge or whatever you want to call them, to load more, to reload, to have the ability to reload. Because again, if you were just planning to shoot yourself, you're not going to have an extra cartridge. That doesn't make any sense at all whatsoever. I also think she was planning to do a lot more than what she had. What she had already done already. Yeah. You think she'll get the guilty verdict also? I think she will. I'll be shocked if she don't. I won't be shocked if it's a hung jury, but I would be completely shocked if they were like, not guilty. It went beyond heat of the moment for me. Yeah. What do you think, Patricia, about the reloading? And I mean, does that make any sense what I'm saying about why would you even have another cartridge if all you're planning to do is shoot yourself? You know? It just doesn't make sense to me. I mean, I understand if, you know, it's not like you can just buy like 5 bullets, you know, you probably have to buy, when you buy ammunition, I'm assuming you buy like a box of however many. But she loaded it. She said she sat in her car and loaded it. So did she load the extra one too? It was like, okay, I'm going to put both of these in my pocket. If you're going to put both of them in your pocket, what are you going to do? Shoot at a target, like to make sure you're good at it before you shoot yourself? I don't understand that. I don't get it. Let's see if I can hit that pop bottle off that fence post. Pachoo! You know? No. Mm-mm. I truly do wonder, though, if it was a situation where she intended to. Like, if that's why she bought the gun, was to kill him. Or if
But first, I have some updates on some of the other stories Cordelia is tracking. First, in Texas,
I don't know.
just
I don't know.
3.5 hours to find Uriah
There are so many trials going on right now. There's another new one, another like beheading one,
as of yet.
where the girlfriend apparently
Brown has been arrested on an aggravated murder charge stemming from a shooting after a celebrity
kills.
boxing event in Miami.
Who's
According to an
this?
arrest warrant, Brown is accused of
Florida v.
stabbing a
Brown.
handgun
Who
from
is
a
that?
security staffer after the boxing match on May 16th, firing 2 shots at a man that he had gotten into a fist fight with earlier. Today, Brown will return to Miami after he waived his extradition. And in California, the mother of missing 9-year-old Melody Buzzard has been arrested, but not in connection with her daughter's disappearance. Officials with the Santa Barbara County Sheriff's Office say Ashley Buzzard was taken into custody on a felony charge of false imprisonment that's unrelated to Melody's case, but they would not give any more details.
That's wild.
All right, let's head back to Tennessee now, where we're in verdict watch in the Broke My Heart murder trial. The jury has been deliberating now for
That's
nearly an hour,
wild.
56 minutes.
I haven't really kept up to date with the Melanie Buzzard case, but that's awful. That little girl is beautiful.
Pastor Brodes Perry. The jury will be able to consider lesser charges, including second-degree homicide, voluntary manslaughter, and reckless homicide. Daniels took the stand yesterday.
Do you guys feel like her emotion on the stand was real, or do you think that she like faked it?
To her family when she contemplated taking her own life.
And do you believe her story? Like,
While we await word of a verdict, we want to still catch you up on more of those closing arguments. Right now, we're going to go back in and we're going to listen to the state's rebuttal.
okay, they're going to replay the state's rebuttal.
The arguments. And the assumption at this point, based on our history, is I'm not going to be up here for an hour, right?
Oh my goodness, I'm getting so sleepy.
And I thought about that yesterday and more today, and I hope you appreciate that. But I don't want you to take that to mean that I don't have anything to say about this case, or that I don't want you to.
You think it was real, Cherie?
Significant that the proof is on this case, because it's significant, and it's almost so clear that it just doesn't take.
I go back and forth with it. I think parts of it was real and parts of it was
So if I can just take a few minutes.
put on a little bit, maybe. I don't know. There was a lot of tears and a lot of snot, so.
The proof is clear.
But some people are good at faking or making that happen. You know, I don't know.
I don't want to be in it anymore. And that shouldn't have been, and probably wasn't a huge surprise to her. Because for the past months, weeks, she was
Like the lawyer said, we only hear her side of the story. Yeah, that's true.
he had moved from Little Rock.
Because her voice crackled when she was trying to talk, holding back the tears. Oh.
So what did she do in response to that? And she can tell you, this is what I plan to do. But the
Well,
problem is,
they're almost at the 1 hour mark for deliberations, so
3 hours.
58 minutes and some seconds.
And that's not disputed. She says, I was going to kill myself.
I'm just wondering if,
She wound up in Memphis with him.
let me go to Twitter real quick and see if I can see any updates. There haven't been anything heavily tweeted about on this case over there on the X. I was looking earlier and didn't really see a whole lot.
I mean, that's overwhelming proof of intentional premeditated murder, and she agrees all that happened. Do you remember there was a discussion, I believe it was in jury selection, about we do things differently than we do in the real world? I mean, I don't know
Yeah, nothing new.
really know what that means. Because what we know is that in the real world,
Nothing new.
Brodes Perry is not here to tell this story. That he was
39 at the
shot and
time of the arrest, social worker from Little Rock, Arkansas.
killed in his own home in front of his wife, and we know
Yeah, see, it happened in 2019.
while kneeling next to her husband,
So it's been 6 years ago.
trying to protect
I
him
mean,
and helping and begging her to stop.
the wife is remarried now.
You know, there's good enough to say, according to her, Tabitha, get out of the way. She doesn't remember anything, but she knows she didn't mean to shoot Tabitha.
Sorry, I'm looking at something on my phone. Oof.
I mean, that's in the real world. And this is hard. I know. Talking about Tabitha. it's a
Wow.
good time just to point out, I mean, there is transferred intent. And so we don't have to prove she was trying to kill Tabitha. Just that she was trying to kill somebody, and she was trying to kill somebody. She did kill somebody. And in that process, she shot and caused serious bodily injury to Miss Archie. So when you have a case like that, with those facts that line up perfect, I get the text, I go buy the gun, I drive to Memphis, I show up at his house, and I shoot and kill him. You gotta come up with something as a defense, right? So the defense is, I'm the victim. And I'm gonna talk about that a little bit in a minute, but I want to talk to y'all a little bit about who she is, who is claiming that she's the victim in this case. It's an almost 40-year-old.
Sorry, I was reading some stuff on Twitter.
Who has a doctorate degree, who has been twice married and twice divorced, who runs her own business, and who voluntarily entered into and started this affair with Brodes Perry. She admitted that. I liked the way he made me feel. I was wanting that kind of relationship at that time. She knew he was married. She had dinner with, she played tennis with his wife. She knew that Tabitha wasn't aware of this affair. You know, there's rules.
Did QB fall asleep? I don't know. I haven't heard back from her, probably.
Well, I mean, one of the rules was we've got to talk to each other on this app that's not easily traceable.
Probably.
Or is that what you would expect? Two people who were married because they were both married when this started, that they might come together and say, you know, we probably don't need to text each other and email each other on our phones and on our computers. Because we got to hide this. Is that
I think she probably did.
Is that manipulative? Can't go out in public with just the two of us because we don't want to be seen as a couple. Is that a rule? Or is that what you expect? When two people who are married decide they're going to have a sexual relationship and hide it from their spouse?
I don't know. I think maybe I'll go ahead and end it because it's 6:07. It's 5:07
Did I miss something?
Central Time.
Or did she say she liked it? She wanted it. to be in
Or
that
I
relationship.
could.
I can't put your plane tickets on my card.
I was gonna say I could leave it running,
Is that what you call that?
and then come back and close it out if they decide to leave for the day, or come back with a verdict. Either way, I don't know.
On the Jerusalem trip because I couldn't make it on wherever the other trip was, Cuba or something. So hey, I want to go on this other one because I didn't get to make that one. Is that you're expected to go, or you want to go hang out with the married guy of my friend?
I mean, wasn't it just this last Friday they did the same thing with the last trial we were watching? Like, didn't they come back on Friday? Like, literally, like 2 hours after they went to deliberate?
All right, right. The state wants this jury to keep their eye on the real victim in this case. We're going to take a break, but before we do, I have an update on another live trial that we've been following out of Iowa. It's called a Metal Pipe Massacre trial. Luke Truesdell is accused of beating these 4 people to death with a metal pipe. Brent Bow, Amanda Parker, and Kiana Ryan, who were all found dead in June of 2024. The defendant allegedly told police that he committed the murder.
It was fast, right?
To quote, make a movie, but the jury won't hear that statement unless
Yeah, they came back
testifies and
quick.
opens the door on cross-examination. And he might end up testifying because now he's pointing the finger at his father. His defense says that Luke's father, Larry Truesdale, was not properly investigated. Swabs from his hands were not tested, and he was able to move freely around his property, which was also the crime scene. Here's today's testimony from one of the arresting officers on direct and some of his cross-examination as well.
Yeah, if I may have the screen clear
Metal
again.
Pipe Massacre trial.
Sergeant Payne, was it determined by you and other law enforcement officers that the defendant was going to be placed under arrest after he admitted to you and Sergeant Egley that he had hit the 4 people with the pipe?
Yes.
And did these events occur here in Lynn County?
They did.
And then I believe we saw on your body cam, after swabbing Larry's hands, Larry was allowed to move freely at that point.
Correct.
And we heard a little bit, it was your understanding that the blood you were seeing was Brent Brown's blood, correct?
Correct.
But you don't know whose blood was actually on Larry's hands, correct?
Correct.
And to your knowledge, those swabs from Larry's hands were never tested, correct?
That's correct.
Now, court has ended for the day, and the jury is set to return on Monday. Truesdale is facing life behind bars without the possibility of parole if he is convicted.
So what did he do? Kill a bunch of people with a metal pipe? What?
Right. Let's take that break now. When we come back, we're going to hear more of the state's rebuttal argument in the Broke My Heart murder trial, so keep it here on your front row seat to justice.
Tonight on Closing Arguments, a 10-year-old arraigned on attempted murder and rape charges after a brutal attack on a little girl. We'll bring you the latest in this tragic case.
Closing Arguments with Vinnie Politan, tonight at 8/7 Central, only on Court TV.
Wow.
Did you murder her mother to try and drive her back into your arms? Oh my God.
Interview with
Lord
a
have
Killer.
mercy.
New episode Saturday
People
night
are
at 8
flipping
Eastern
nuts,
and
man.
Pacific, only on Court TV.
All right, you guys. I think I'm going to go ahead and end it. I don't think they'll come back with a verdict, but then again, you never know. What should I do, Sherry? Should I end it? And then no matter what happens, we'll just wait and discuss it on Monday? Or should I, just keep it going and then just come back whenever they decide to leave or have a verdict tonight? Because I'm afraid that I might, if I go in there and sit down, I will fall asleep. I know me. I know I will. Because I've been up and running and busy since 5:30, so I'm sleepy. But I don't know what to do. Yeah, I don't know what to do. I don't know what to do. You feel like it's nap time too, Patricia? Mm-hmm. I feel nappy nap time. I'm sleepy. I don't think they will have a verdict today. I don't either, but you know what's going to happen, right? What's going to happen is if I end it literally like 35 minutes later, people are going to be messaging me saying, Jenny, they have a verdict. They have a verdict. You know? And then my luck, I'll be in there conked out or doing something, you know? So, you already had yours, Morgana? Was it a good one? How long did you nap for? Donnie took a nap, and then she came in here and said, I fell asleep. And then I said, did you have a good nap? And she never did answer me. She ain't been back since. So I think she probably went back to sleep. Oh, 2 hours? That's a good nap. That's a good nap. Yes, ma'am. I can't stand the people that are like, I'm going to lay down and take a nap. I just need a little cat nap. And they'll lay down for like 10, 15, 20 minutes. And then get back up and be like, oh, that was so awesome. And now I can't do that. I can't nap like that. If I'm going to take a nap, it's going to be minimum 2 hours. Minimum.
All right, folks, we'll get back to that state's rebuttal argument in a minute. Now, to first bring in our guest for this hour, joining us, criminal defense attorney Silva Megadichian. Silva, great to see you.
Okay, I'm going to mute this a little bit because they're going to end up striking me if I don't, turn the volume down. Right, Jenny, that feels like gaslighting. Yes. It does. Raving about a 15-minute nap. I can't even fall asleep in 15 minutes. Like, it takes me 15 minutes just to get good and comfortable. And then I still haven't fallen asleep yet, Like, I have to get myself ready and geared up to take a nap. You know what I mean? I don't know. Margaret says in 45 minutes I can take a nap. Hey, Margaret. Oh. Goodness. That woman's gold chain, like, I haven't seen anyone wear a gold chain like that, and I can't tell you, since, like, the 80s. And roll over on people, too. Yeah, Margaret's good for that. Sign off from your work day, then. Good deal. My Alexa is over there playing music. It does the music thing at 5:55 p.m. every day still. That one is, have you ever seen the rain? It's older music that comes on. I don't know who gave her the playlist to start playing. It's always that music. However, in the morning, what is it? Aussie stuff comes on. And he didn't even set it for that, like for an alarm. I mean, he set music for an alarm, but he never set it for like Ozzy. And it's funny because he did like it didn't even do that after Ozzy died. It was playing Ozzy long before Ozzy actually passed away. It was so funny. Oh, it was funny too because I was watching a video of someone. I can't even remember what the video was the other day, and someone had said something about Crazy Train, the song Crazy Train, and she said, you know, Metallica and all, and I was like, honey, that is not Metallica. No. Funny. CCR, yeah. I like CCR. I like CCR. Oh, I used to have one of their the CD of theirs forever ago. I think I bought like 2 copies of that because I burnt the first one up till it like skipped all the time. I couldn't listen to anything because the CD skipped all the time. Those were the days. Those were the days. Okay, you guys, I'm calling it. I want to go. And if they end up coming back with a verdict tonight, we'll all just discuss it on Monday. Okay? If they don't come back with a verdict tonight and they come back with a verdict Monday, then we'll watch it then. Okay? I'm gonna have to go. I'm getting sleepy. So I will see you guys later, taters. Yeah, I can't hang on anymore. I'm sleepy. Try and talk myself out of it, but I can't. We'll be back on Monday to discuss, like I said, whether the verdict comes tonight, or if it does, then it does. We'll just, like I said, discuss it on Monday, and if they don't come back with one, then we'll watch for one on Monday. Unless they come back tomorrow, I don't know. They might come back on some, judges let them have them come back on the weekend. I have no idea. So, but we'll keep an eye on it, and we'll talk about it when we're able to. All right, you guys have a good weekend. Thanks for hanging out with me all day today. It's been a lot of breaky breaks kind of day. A lot of fast forwarding today. So, all right, I love you guys. Have a great weekend.